give the memos, we will see.
Yes, my lord.
My lord, I may be pardoned, my lord.
Right.
Belgium matter, the petition
Belgium.
Lordship, fresh matter.
tomorrow, my lord.
Not tomorrow. We'll adjust, but I'll give a short date, don't worry, within this week.
Pardon me, Lord.
Belgium matter, we'll
Item 81, my lord.
yes.
Old matter, my lord, some evidence copy required, my lord. Finally, 1 week after, my lord. 2011
Revision.
revision, my lord.
After the board is exhausted, I'll take up all the revision matter. We'll find out how to adjust it because the revisions are not moving at all. So, are you prepared to argue?
1 week after.
Then can I put it on 6th?
6, yes, my lord.
Huh?
Yes.
Put it on 6th.
And also 92, my lord.
90 to 81 and 90.
81 and 92.
Both on 6th.
Let us see.
Pardon to mention, item number 3.
3 will come. Will
No, just item number 3. I miss the brief. I will reconstitute the brief. 1 day time is later. Day after tomorrow, anything.
okay.
Item number 3.
3 adjourned.
Item number 81, sorry, 70. Your lordship is directed to appear personally appear to the petitioners. One petitioner has appeared on that day. Rest 2 will be appeared today.
Hmm.
But misfortunately, they are not available. 2 weeks after.
Potato.
Matter has been compromised.
Why they are not available?
They are working in the outside of the state. They have
Then
not-
I'll quash the proceeding, quash the petitioner who has appeared, and other 2, we can't wait for them.
Right.
It is a settlement matter. You should appreciate that. Let it come. We'll see. Let it come.
Matter.
I'll quash insofar as the petitioner who was present, and the other people will face it. What will
Item number 6.
Item number 48, madam.
I'll call.
Item number 48. But matter compromise.
Today you want to go home early, it seems.
No.
Every matter you are adjourning, asking.
That is the whole difficulty.
Right.
Otherwise, I never.
Okay.
Item 48, victim, their matter of compromise. The victim is suffering from fever. So she is unable to.
It is settlement. Settlement sorted.
Sorted with the 40.
48.
Upper appear we question the victim by. Item 84. Criminal review. Item 84.
Right.
1 week.
All the matters I'll take up. We'll see how we can deal with the revisions. After immediately adjusting the board, I'll take one after another. I'll accommodate, don't worry. I'll accommodate.
Your lordship.
Your lordship, item 55. Item 55. Last occasion, your lordship directed to appear in person, both the parties.
Huh?
Appear in person. Matter has already been settled.
Huh.
I am for informant. Informant is living outside of the state of Mumbai. Ticket is not available, so he is unable to come.
Let it come, we'll see.
Item
number
65.
Both the parties present.
Interim order may continue.
No, I'm not adjourning. Let us see.
Pardon.
It's a settled matter, no? I'll just see. I'll continue. The interim order will continue. Let us see why. What is it?
Item 65, my lord.
Item
Yes.
6.
Item 65. It's a vigilance matter. We have sought for instruction from the government. It is a matter relating to quashing the departmental proceeding. The criminal proceeding will be quashed. Exoneration departmental proceeding, criminal proceeding. I'm not well today. So let it come. Any other interim order is
Who
there.
is there from 65?
My senior Mr. Dhal is appearing. I will intimate him.
Mr.
Mr. DP Dhalmal.
Please intimate.
I'll intimate him.
He's not well.
Item
My
number
lord,
61.
item number 15, my lord.
Interim order may continue, my lord. That interim order. Much obliged.
Item number 15 may kindly be taken up 2 weeks after, my lord. It is a compromise matter. Already the OP has been appeared, my lord. He is out of station. Kindly taken up 2
Who is
weeks.
out of state?
The OP council, my lord.
Forget about council. If the parties are there, we will.
No, parties are not there. Also, the victim has been suffering from fever, my lord. Kindly taken up 2 weeks after. I have taken the instruction, my lord.
So see,
1-5.
compromise matter, either you come or we will dispose it up.
I have taken up 2 weeks after, my lord.
We can't-
And
See, we can't be waiting for the accused for gracious presence in the court. Dismiss it.
let it be taken up 2 weeks after, my lord.
Item
Item number 52, my lord. A connected matter is there in this case, which has been adjourned on 18th April, my lord.
18th April.
CRLMC number 201 of 2023 Another matter, CRLMC 427 of 2024, connected matter are there, my lord.
And the problem is who is from the other side, I don't know.
No, nobody has appeared, my lord. Notice has already been served, my lord.
Okay, all right.
Item number 61.
Today I'm holding the court. Why are you worried? I'll take up all the matters.
My lord, may I
Item-
be permitted to mention, my
One
lord?
minute, 1 minute. 1 minute.
Item number 61, my lord.
Yes, LHC 4644 of 2023, your lordship. The present petitioner is the brother-in-law of the lordship man. So he has no role at all. What do you want? Passing. Give it, we'll see. Your lordship kindly tomorrow. Tomorrow, what is the question of tomorrow? The board is already, see, the matters are listed and everybody is coming, taking it. What to do?
Last week.
And you advise your brothers not to take it then.
Last week, your lordship, I mentioned before, your lordship, so you.
What to do? You just see.
Lordship.
117 matters have listed,
Let me
thinking
just-
that something will move.
I
And
know.
you are asking for adjustment, what to do?
I understand your lordship, kindly consider your lordship and take it.
Just see, it can be accommodated, anytime.
My lord,
Item number 61, my lord. And then next. Item number 61.
Ah.
Next.
Is the first matter?
Name first.
After notice,
After.
where is the other side?
I am.
To bring other side, it can't be like that.
Pardon to make a mention.
Article 72.
Yes,
And for the petition of the compromise matter, I have taken consent of the council for the OP number 1. OP number 1 has undergone an operation. So matrimony called after 1.
it is, it's settled, matter is settled.
Already settled, we have the appeal.
What is the offense?
498.
Okay, give next week.
my lord, item number 96.
No, madam, one of them. The OP number 1 has undergone an operation.
Give it in May.
My lord, 61, I am for the petitioner. 61, I am for the petitioner.
The same matter,
61,
61 what
I
happened?
am for the petitioner.
Huh.
It is taking time, my lord, I do not want.
Who is taking time?
So entry of-
Who is, nobody is
Also
taking.
not written.
61 nobody.
Pardon to make a mention, lordship. As a matter, it was listed on 14/3. Then it was ordered at 19/3, it will be listed, but in wrongly it has been ordered 19th May.
19?
May.
What is this matter?
Question on the ground of amicable settlement.
You thought adjournment?
No, your lordship. It was decided that on 19th the parties had to appear. But in wrongly it has been typed as 19th May. Your lordship may kindly see.
It is a matter, settled matter.
Yes, your lordship. A notice has to be issued. It was not issued on that day. It was.
Why, if you have settled the matter, bring them, I'll watch it.
Yes, your lordship. A date has to be given.
When will you bring?
Any date next.
Tomorrow?
I've talked it out. So next week.
Or you decide and mention? Decide and mention. Whenever you bring them, come here, I'll put it in the same day also at 2 o'clock, I'll take it.
My lord, item number 96.
Get your party ready, whether they should come or not. I can't wait for them.
They're ready, sir. Yes.
Bring them, ask them when they can come and mention. Either on that the same day, 2 o'clock I'll take up, or the next day I'll take.
Obviously.
Item
2 manner, for a 2 withdraw, not just for.
Withdraw.
item number 90,
Withdraw.
96.
96.
On behalf of
Revision matter,
Acharya.
wait, revision matter, I'll take it up one after another.
Mr. Acharya is not in.
It's all right, it will be adjourned, no problem, but we have to, see which are the matters, whether parties are surviving or not. We have to just see. Wait.
Okay.
Yes.
Directed
148.
That is not the mandatory. It is May what it has been given.
So what do you want? You don't want. You don't want to pay
My lord.
after conviction.
Right.
Will you pay installmentally? I'll pick it up. Otherwise,
Installment, yeah.
we'll take it up. Get ready. What is the amount?
My lord, 6 lakhs.
6 lakhs.
6 lakhs is 20%.
6 lakhs, 20%. So how much it comes to? 120. And installment, you tell me. How much how will you give?
50%.
50-50, 2 installment. 2 installment. Take it up tomorrow.
Pardon to me.
And don't wriggle out of it. I'll record it and dispose it up.
And pardon to mention, matter was fixed at 28 March 2024, my lord. The court is not different function.
Sorry, I'm so sorry.
My lord, both the party, my lord directed both the party present and filed joint affidavit. Matter is a compromise.
Huh.
Next to any date, man.
Where are they?
My lord,
Are they coming?
नो 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 28 रे ना आसुतले मो मना कर तुम कोर्ट हेलानी मु मेंशन कर तुम जणेल तो आसे कोर्ट नेक्स्ट वीक एनी डे
And bring the party.
माइल माइल both party
Give it
joint
date
affidavit
today itself so that they will not be confused.
नेक्स्ट वीक एनी डे दूर काकटपुर आसीबे
हाँ,
गोटे गाड़ी करी आसीबे एंटायर
Okay,
फैमिली
it's all right, no problem.
नहीं मैडम हाई लो प्लस नहीं
Nine.
नहीं
Okay.
May I please your lordship?
Pardon to mention, your lordship. Your lordship, this is for quashing of FIR, wherein the allegations are under section 307. Your lordship, I had obtained an anticipatory bail, but with the condition that the injury should not be grievous. However, they have produced a fabricated document, which I can prove, for which I have,
What do you want?
I want to quash the FIR, your lordship.
You are on bail. What is the urgency? Give me.
I'm not on bail, your lordship. I could not surrender since they obtained a fabricated medical certificate, and that is why I'm
The
challenging.
prosecution has got a fabricated document.
Yes, your lordship.
Why the police is against you?
Your lordship, I have some evidences which were,
You give it, we'll see.
your lordship may take it up any day.
It's item 109.
All revision, I'll take it up one after another. Don't worry.
stay order signed for the Union of India trial of the state affect aim of states in
2023. What is the case?
cognizance the petitioner challenging the order of cognizance.
Right?
The petitioner himself is a railway employee. He committed theft of railway property. Apprehended. Departmental proceeding was initiated as well as criminal proceeding. In criminal proceeding challenging the petitioner order of cognizance, filed this CRLMC and
What happened to departmental proceeding?
committed.
When proven guilty.
Fine.
Proven guilty. Take it out, we'll see. We'll see how can we address it.
My lord, I have challenged the cognizance order, my lord. Here the IA is pending, though the matter is admitted. After appearance of the informant, the IA will be taken up. That is the order. The IA is pending.
Yes. Any more?
I may be pardoned to make a mention.
Yes.
I have mentioned this matter before your lordship, and your lordship, please to direct. It will come in next week, but it has not come.
What is this
That is the
matter?
matter relating to taking cognizance, my lord. CRLMC 342 of 23.
Right.
When we taken fresh admission with stay.
What is the matter is about?
Matter is taking cognizance. The offences are compoundable only except one offence, and another is the civil court. It has been decided between the parties in order to harass.
Are you going to settle it or what?
No, it was settled in the civil court. The complainant informed in the civil court by giving an undertaking that it is settled. And it is between the same family members.
Take it up, we'll just see how can we adjust.
One is
Belgium
Not tomorrow. We'll have to adjust. Everything will be upset. If we'll, in between,
My lord, may I be permitted to mention?
matter.
1 minute, Ms. Patnaik, we'll just see.
The Belgium matter.
Give it, Belgium. Take it.
Belgium matter and another is my lord.
Belgium,
No, it's compromise.
An-
I was mentioning the parties will compromise.
tomorrow. Take it tomorrow. 2 o'clock? Bring them at 2 o'clock.
Item 109.
What is the offense, by the way?
Normal office between the family members,
Tell me the offense.
294, 323.
Bring
Item
Yes.
Item 109 on behalf of SK Pradhan, because you has a medical problem, kindly taken up 2 weeks afterwards.
medical problem.
Item 69, my lord. After notice matter, I am appearing on behalf of the opposite party, my lord. I pray next week, my lord, because of the illness of my wife, I want to attend her.
Who is for petitioner?
Petitioner, my lord. Last occasion,
No, you have to tell the petitioner, otherwise he will come and say, behind my back, date is given. That's the problem.
ମୋର ଏଇ ପ୍ରୋବ୍ଲେମ ହେଇଯାଇଛି ନିଜେ ଆସିଛି କହିବା ପାଇଁ ବିଶେଷ ହସ୍ପିଟାଲରେ
I
ଗଲା
understand. Note down କରନ୍ତୁ. He has a medical problem. Okay, ଆପଣ ଯାଆନ୍ତୁ କିଛି ଅସୁବିଧା ନାହିଁ. We'll see. Huh?
ଆଜ୍ଞା
At its call, we will adjust.
Aye.
Okay, you may go.
Item 98, I need some time, my lord.
Revision. I'll give the date. Let us see. I'll give you. Okay.
So on that time, I may not be present because I have some
Note
problems.
it down.
19th.
Why are you seeking time?
Because the old matters come, but I have to take
It's the old matter,
some,
therefore we have to finish.
some instruction. I need some instruction from the clients.
May pardon.
Get ready, because old matters we have to
Yes,
finish.
yes, I will be ready. I will be ready for that. I need some times.
Yes, sir.
I may pardon. Item 37. There is a initiation is going on to settle the matter between the parties. Hence, I seek some time.
It's a fresh matter.
Fresh matter.
37, write down. The counsel for the petition submit that there is a possibility of settlement in this matter. Hence, he, in order to explore the possibility, he seeks adjournment, adjourn to.
I beg pardon, my lord. One.
Yes.
One urgent matter, my lord, out of late, my lord. I'm little late, my lord.
Sorry.
So, I'm little late, my lord, to after the.
Yes, yes. What do you want?
No, this urgent matter, my lord, CRLMC number 999 of.
What is the agency?
Urgence, my lord, the petitioner said the private limited company, my lord. Under the OJS Act, my minimum OJS Act, my lord, a proceeding was has been initiated and cognizance has been taken.
Cognizance.
My lord.
You are on bail? No.
Beg pardon? No, not well, my.
Okay, give it.
Here is a matter 205 petition has been rejected and this honorable court has stayed the matter. I am for the opposite party.
Where is you? You are mentioning it.
Yes, man.
Give it. The date might have been given in this. There must
That
be a
is
date.
2022 matter.
But what? 2022. I have not.
No.
Stay is granted by someone. We'll see.
Online.
Yes. Yes. Online. Mentioning. Yes.
Yes, my lord. My lord, yes, my lord, one CRLMC 4002 of 2023, my lord, fresh matter, challenging the dismissal order under 227 proceeding. My lord, in spite of various memos, this could not be listed. This is a fresh matter, my lord. My lord,
Give
can
the
I
memo.
pray for on 5th? Yes, my
No,
lord.
you don't
My
decide
lord,
the date.
Yes, my lord. My lord, I am praying. Just I am only praying. Yes, my lord. I'll give.
It's
My
all
lord,
right. We'll see. Possible 5th also. No
Yes,
problem.
my lord. My lord, another matter CRLM 228 of 23. Two CRL, my lord.
Connected matter. Both are connected matter.
No matter, my lord. Different matter, my lord.
Give the memo.
Yes,
Do you have anyone? Vote.
Yes, my lord. My lord, I'll be handing over the memo. Yes, my lord.
Please give it. We'll see.
Yes, my lord.
Next. Any mentioning?
My lord,
Mr. Om Prakash.
my lord, I want to mention CRLMC
Yes.
98 of 24.
Yes.
Case may kindly be listed, my lord.
It will be listed. What is the urgency?
The bail. The case of bail job.
Bail jump. Give it. Tell the number.
The CRLMC 398 of 24.
392. Okay. It will be listed next week. Okay.
Obliged, my lord.
Okay. Yes. Let's start the list. Yes.
May I please?
Yes.
Challenging the order of cognizance, my lord, in a complaint case, my lord. Initially, FIR was annexed and FIR was lodged under section 498, 304B, 302, and 34 against the petition against the 4 accused persons, my lord, including the present petitioners, my lord. After investigation, charge sheet was submitted against the petition number 1. And there is
Petition number 1 is Manoj Behra.
Husband.
Okay.
And prosecution failed to establish the case, therefore no charge was framed against the other accused person. Thereafter, one complaint was filed, present opposite party note 2, which through by protest petition, in which my lord cognizance was taken under section 498, 304B, 34 of IP.
Show me the statement and 202.
My lord, annexed are
Complaint is at page 36.
my lord.
Come to 36. Total delegate. Examination of the complaint.
I have filed the case against the accused Manoj Behra, Chandrama Behra, Mamali Behra, Kaya Behra. All the accused persons are known to me as my daughter Sarmishta, who is no more now. As married to Manoj Behra, Magrosima, 7 December 2020. And other accused are mother-in-law, father-in-law, and sister-in-law of my daughter, my lord. The marriage solemnity as per custom caste, they have demand one motorcycle rupees 20,000 cash, and for all this demand has been on the date of marriage of in Bedi, my lord. Again, they demand a chain and always assaulted and tortured my daughter Sharmishta, which my daughter has intimated me. After the 10th day of marriage, my daughter has come to own house and stated that her in-laws, husband and demanded therein. They all mentally harassed her for all dowry while stating that if it is not of good quality. Within 1 year, 3 months of marriage, she had to own house twice. Each time when she come to our own house, କାନ୍ଦିକି କୁହେ ମତେ ଏମିତି ଘରେ କି କାହିଁକି ମ୍ୟାରେଜ କଲୁ.
Come to para 7. On the next day, 8 AM, I got.
Next day 8 AM, I got to know from Dinabandhu Mudili, Manoj's mamu, who is the uncle of my son-in-law Manoj, that your daughter got senseless by taking medicine come to her village. Then by receiving such phone call, me and Nipukaran in his bike and reached at 10 AM in Salavanga village, my village in law's house. When I reached, I found my daughter lying in the bedroom of my daughter. Neck has two marks. Such is light reddish in color, and it appears that someone has pressed her neck. Such is there no other enter injury freedom for badly. I took photo of it when it want to exhibit.
These are the allegations.
Yes.
There are allegations, my lord, there.
What?
But same, but in the initially,
She was found.
these allegations, these allegations are
Neck was placed, and
these
he took the photograph, and that photograph you want to exhibit.
that
And all these things.
that
Also, charge sheet sounded 49306, my lord.
306.
Subsequent
But
protest, my lord,
304 be
marriage within 1 and 3 months, 1 year, 3 months, my lord. There
There are materials.
Stage-
Cognizance is rightly taken.
Charge treasury, they can.
I renew my at the framing time of framing of charge.
Right, and petitioner seeks to withdraw this petition at this stage to raise all his points at the appropriate stage before the court below. With this liberty, petition is discharged. Yes, next. Two. Two. Withdraw, 3 gone. Yes, 3 minutes. 4.
May please, your lordship. May please, your lordship, my lord. My lord, the case, my lord, the petitioner is a innocent employee. He obtained a loan, a personal loan, and repaid the amount. But the thing arose when the complaint was raised that 51 loanees, they committed some fraud, having hand in glove with the bank employee. The present petitioner, who was clean loanee, has also named in the affair. May I invite lordship's kind attention the bank officer, including the top higher ups, my lord. May I invite lord's kind attention to the page 23, my lord.
Show me the charge sheet. Show me the charge sheet. Forget about
That's it.
Show me the charge sheet and 161 statements.
Yes,
Any
that,
material
yes,
is there,
yes.
then
161
copy of charge sheet. Come
Yes.
to 26.
Page 24, my lord. That is 161 statement of the bank officer, my lord.
No, come to 26. Charge
26,
sheet.
my lord.
What is alleged against you? You are Mr.
Ramesh Chandra Subudi.
Subudi. Just see.
I'm serial number 27 in the order of cognizance.
Yes. Is there anything against Subudi? Just see.
No.
Just-
My lord, I paid that is the admission of the bank officer. My lord, may I invite lords to 1 point. Page 20 copy. सब दीजिए ना.
Foreign reporter FIR कर देंगे.
ओहो.
1 crore loan was taken.
It's old, 51 loan is, my lord. But the bank officer said I paid the amount and annexure 2, my lord. Annexure 2.
And the field officers, manager of the bank in connivance with each other. You are one of the loanee.
One of the loan I paid. That is the bank officer said that I paid, and also they issued the no objection. Annexure 2, my lord.
But
Pays,
paying is something different. Whether you have manipulated the documents
no.
for getting
that is my humble submission. There is no allegation that I have manipulated and obtained the loan.
Show me.
Bank officer said that I repaid the amount.
Where is that?
My lord, may I invite also kind of page 24, my lord, the bank officer.
What is the loan amount?
Loan amount is we have taken 3 lakhs, 2 lakhs personal.
You have taken.
Yeah, and I repaid.
Show me.
Annexure 215, my lord, for a kind, may you let kind attention to page 15, annexure 2, so that your lordship will have a impression over the matter.
Okay, 15.
That I 15. Annexure 2,
Yes.
close. My loan is closed. My lord, on bottom, my lord. Your lordship,
Close.
look close. Then, my lord, may I invite your lordship's kind attention to the statement of the bank officer, top page 24.
Lord.
Come to
Lord,
page.
last
Hmm.
last but two paragraph, Lord. Out of 51 loanies, 12 loanies, namely so and so. I'm in.
Out of 51 loanies,
I'm
12 loanies, namely Prashant so and so, so and
I'm
so.
three. Number three. Ramesh Chandra Subudi. Paid. Has repaid the loan amount. So this is the material and
Yes.
But charge sheet, my lord, in fact, shows that, my lord, that is not nothing, my lord, in the charge sheet that he has paid the loan, my lord.
But he is showing the bank account, he is showing the
Yes.
statement of the.
For that, my lord, I have taken.
So why should he be an accused?
Pardon?
And why should he be? There are
My lord.
51 people have
Okay.
taken loan
Yes.
of 1 crore something,
My lord.
and 12 people have paid,
My lord.
Yes.
and all the 12 people were not made the accused, except except him. There are 27 accused.
yes.
My lord. My lord, no. My lord, page note 23, my lord.
Yes.
Out of 51 loanee, 12 loanee, namely Prashant Kumar Pradhan,
Repaid.
Prahlad Mahanti, Ramesh Chandra Subudi petitioner, Sarath Naik, Manmohan Mahanti, and
So and so has
my lord.
loanee has
Repaid.
repaid
Total loan.
total loan amount
With interest.
with interest.
With
My lord.
interest.
That part, my lord, I have to take instruction from the IU, my lord. Whether, in spite of that, they have been charged, my lord. Whether they have manipulated the document or not, that is, my lord. The allegation against them, all of them.
Show me something.
For that, case is required, my lord. Otherwise, my lord, from the charge sheet, can, my lord, 1/6, all the 1/6.
You are on bail.
We can.
Yes, I'm on that.
And then, in
I'll-
fact,
After retirement, I'm Lord.
I'll stay
Yes.
My lord.
proceedings for him.
Yes.
Right now.
Obliged.
Mm,
A sword of Damocles hovering
the-
over my head
the
after retirement.
Allegation against the petitioner is that he, along with 50 other, 50 others. 51 means you.
Oh
and
yes,
50
including
others.
51. Sorry,
50
sorry.
others,
I stand for
have
correction.
obtained a loan from the bank to the tune of 1 crore. How much? 1 crore. I'll tell you. 1 crore. 17. 1 comma 17 comma 05 comma 000. Loan by manipulating the document, etc.
Loan documents.
Loan document, etc. etc. Insofar as the present petitioner is concerned, he has obtained a loan of rupees 2 lakhs. Loan of rupees 2 lakhs. Land counsel for the petitioner has pointed out from the bank statement at annexure 2 that he has repaid the amount and his loan account has been closed. And he has also drawn my attention to the statement of the
Bank officer.
what is he?
Sirish Chandra Senapati,
Sirish Chandra Senapati,
branch manager.
The branch manager of the bank, who inter alia stated in his 161 statement, inter alia stated in his statement under 161 CRPC that the present petitioner and 11 loanees have repaid their loan amount. Therefore, the petitioner has been wrongly arraigned as an accused in the charge sheet, along with 26 other co-accused persons. 26 other co-accused persons. Hence, the petitioner seeks. Hence, the petitioner attaining the order of cognizance dated. Order of cognizance dated 7/11/2017.
17.
What is the stage of the trial now?
Trial has not yet begun.
Charge has been framed.
Charge has not been framed. The status.
You must tell me if the charge is framed, then I can't enter.
The charge has not been. So I understand because this order goes.
So legal counsel for the petitioner on query from the court submits that although the cognizance was taken on 7/11/2027, charge has not yet been framed. Therefore, he seeks the indulgence of this court. Issue notice to the opposite party, returnable within 2 weeks. In the interagnum, the proceedings in CT case number 4277 of 2013, pending in the court of SDJM Bhubaneswar, qua the present petitioner.
Only.
Stay.
Lord, there are, I beg your pardon, have 54 accused persons. The total 54 accused
So,
persons. 54.
50,
What is his app?
54 right now, na? 53 koda.
Yes, yes, yes,
50, 50 along with the na? 53 along with them.
Obliged, Lord.
Okay.
Deeply obliged, Lord.
Item 5, pass over minor.
Pass over, okay. Yes.
My lord, this is a case under section 138 of NI Act, wherein the present petitioner is the accused. A petition was filed before the learned lower court for the production of two documents, the account statement and the books of the complainant's firm. The same was rejected by stating that it is not desirable at this stage for the to allow the production.
Where is that order?
Annexure 1, my lord, page number 11.
What did it say?
In the page number 13, the operative part says, at this stage, the court does not feel it desirable and necessary to produce the document as
What
sorted
did it say
for.
up to the
The prosecution evidence has been concluded and the defense evidence is yet to start, my lord.
yet to start?
Yes.
What do you wanted to summon?
The account statement and the
Account statement of?
the complainant's firm. And the books of the complainant's firm.
Because that the complaint is what is your defense?
Those documents will be necessary to show that we do not have any liability to discharge.
See, everything complainant evidence is closed. Now you are the accused.
Yes,
you
my
have
lord.
to leave the defense evidence. Where is your application? Show me. Where is your application?
Annexed 2, my lord, page number 14.
Page 14.
Yes, my lord.
Read that application. What are you? Read that thing. What have you written here? Who can read it? Read it. What is your application?
That the case is fixed today, that the pending amount of the case is rupees 25 lakh, and the complainant is a proprietor of Agrawal Trading Company. As the government of the complainant complaint petition shows the transaction of the complainant and the accused is highly required, and for that the account statement and book of the Agrawal Trading Company Limited of the complainant in connection to the accused transaction be produced before this honorable court. Hence, pray that.
What is this in handwriting? You written a slip and give it to the court, and the court will allow. Just see your application and rightly reject it. Just see your application. If you would have been in the position you would have allowed it. This doodling in a small paper slip and give it. Allow. So rightly rejected. I'm dismissing you, giving liberty to move appropriate application. This is not an application. Rightly rejected. Write down. The under what provision, which account, what, nothing is there.
Hello.
What kind of a defense is there? The petitioner is assailing the order dated 21/9/2022, whereby his application seeking production of the what production of what?
Account statement and book of the
statement of the of Messrs. Agrawal Trading Company for his defense has been rejected by the court below on the ground that the application is completely vague and devoid of any merits. The perusal of the application at page at annexure 2 indicates that the application is indeed completely vague and without any particulars. Therefore, no fault could be found from the order of the court below rejecting such application. Therefore, no interference is called for. However, petitioner is given liberty to move appropriate application with details disclosing as to why and for what reason he wants to summon those documents. If such application is moved, the trial court may consider the same on its own merit. Dismissed. Yes, next.
So next.
Item 7.
7.
We have a scheme and we permit to place the matter, my lord.
Sir, here.
Yes, my lord. This CLMs has been filed for the expeditious disposal of the 1cc case of 240 of 2019 for the offense under section 138 of NI Act, my lord.
You are the complainant.
Complainant.
You filed it on
2019.
1cc case was filed in 2019.
19.
Right on. The petitioner is the complainant in the 1cc case number 240 of 2019 under section 138 NI Act. He has filed the complaint case against the opposite party on date questioning, page 9. Which date you have filed it?
The month, the exact date, my lord, 2019, my lord, October 2019.
19 consists of 12 months and
Yes, my lord.
365 days.
Yes, my lord.
You tell me the date when you filed. And you see your application, nothing is there.
Check was bounced on 11/9/2019.
Where is that? Where will I get? In the application, it is not there. Where will I get that you have done it on such a date? Show me the date. When have
Orders
you
start
filed?
from 24/1/22.
Huh?
Prior to that, there is no such order, my lord.
Where is that?
Page 10. Orders start from order dated 24/1/22.
24/1. You complaint there is not. 24/1/2022.
Notice ಪಡೆದ
See, the proceeding started in 2022. 2019 you have filed. You don't have a date when you filed. How will I give indemnity to you? At least you tell me the date. Pass it over. Come and tell me the date when exactly you have filed. I will dispose it of saying that 2019 petition. The statute says within 6 months it has to be done. So I'll pass a order for expedite.
Yes, my lord.
But I should know the date when you file it. Whether you file it or not, that is also doubtful now. You tell me immediately. After pass it over. Get me the exactly date when you file the petition. Okay. Right.
I may please, my lord.
Yes.
This occurrence took place in the year 2000, my lord. The allegation is that the named accused persons in the affair, they killed the brother of this informant. My lord, may kindly see I am drawing my lord's kind attention to the affair relevant page of the affair at page 9. At page 9, my lord, 9 accused persons were named, those who were assailants in the case. But this petitioner's name of this petitioner.
Okay, what about your earlier CRLMC 1496?
CRLMP.
Yes. That was dismissed for the same.
That was restored again.
Dismissed, then dismissed on the ground of non-prosecution.
It was then.
And thereafter you moved an application IA.
Yes.
What happened to that?
That was restored to file. This application was restored to file by that.
And this is that the same petition, huh?
Yes, yes.
Okay. Yes, tell me.
My lord, may kindly see page 9. This name of this petitioner is Maggie alias Maguni Malik. At page 9, my lord, the named accused persons were there. Those who are the killers, they were those.
Page 9?
Page 9.
Maguni Malik, huh? Page 9. Come to page 9 then.
Yes, my lord. Nonda Parida, Dako Parida, then Okura Parida, Jogi Swai, Bhagi Swai, Sonia Swai, Tiki alias Megha Swai, and Chatia Swai.
Your name is not there.
Not there.
Right.
Then thereafter, charge sheet was submitted in the year 2001, my lord.
2000?
2001.
This
I have
FIR
given, yes,
is of 2000.
I have given that.
Yes.
My
Where
lord,
is-
charge sheet.
Where is the
Charge sheet
here?
point at page 12, my lord. Annex 2.
Where is your name?
Final 9/1/2001.
Where is your name?
My lord.
Where is your name?
No,
Charge sheet.
yes, in the charge sheet I was named. Then yes,
It is possible. Why not?
my lord.
It is possible. Why not?
Yes.
Your name is
Then-
not there in the
yes.
FIR doesn't mean that your name
Yes,
is not.
my lord. I am not on that point.
Yes.
Then subsequently thereafter, at the initial stage, the matter was then settled between the parties. Basing upon that, my lord may kindly see. Basing upon that, in the year 2002, page 26, my lord may kindly see.
Page 19 is your name. Page 19 is the charge sheet. That is Magi Malik.
My lord.
Your name is there.
Yes.
Okay.
Then, my lord, the matter was amicably settled between the parties.
Right.
Then, my lord, then two accused at page 26, my lord, a full-fledged trial was held at page 26. 26. Annex 3 series 26.
Yogi and Bhagi.
Yes.
Yes.
Yogi and Bhagi in the year 2002, they faced the trial, my lord.
Yes. What happened?
And they were acquitted, my lord, on the basis of the compromise, my lord. Then, my lord, may kindly see at page 35.
Where is compromise? Which paragraph?
My lord.
Which paragraph you are relying upon?
None of the witnesses they say implicated.
Of the decision.
Yes,
which paragraph? PW7, PW5, PW1, 2 have also been examined as the independent witness. I will change to the proper stated that the decision on the diet about 4 to 5 years back. They cannot say the father for rejection to. It is not on compromise.
Although that is not there in the so the
why are you telling this? It was on the basis of the evidence they were acquitted.
Yes, ma'am.
Whatever.
Then, my lord, may kindly see page 35.
See, come to page 32 first.
32.
Come to page 32. Last paragraph. Page 12. Para 12.
Part 12.
It reveals from the evidence
of
PW 1 to 7 that the deceased Artha Pradhan died receiving multiple injuries on his person. And from the trend of the cross-examination, it has also come to the light that defense has never disputed the fact that the deceased met with a homicidal death.
All these things I am not.
And in the aforesaid, read it in the aforesaid situation. Artha Pradhan died of injuries cannot be disputed.
Yes.
But the question remains as to how for the prosecution is able to bring home the charges against the accused person.
Then, my lord, I humbly submit, my lord. Subsequently, two other trials were held at page 41, 29, my lord, may kindly see. Page 35.
Again, they face the trial and they were also acquitted. And you have to face evidence will be recorded.
Yes. Therefore, I am some. At page 41 also, another trial cover, all the co-accused persons were released.
Yes.
And no, now my yes, most I could say I am not on the that point. Now, the evidence of the witnesses were recorded on section 299 CRPC. 299 CRPC, in the absence of the absconding accused, evidence can be recorded, and that can be used even if after the death of the witnesses. In that also, no evidence is. My humble submission, my lord, is that I'm not that in the case of 302. It is not that whether I am not praying for passing of the proceeding, my lord. Now,
what do you want then? You surrender, I'll expedite it. As simple as that.
Yes. I may be released from bail, because now it will be only the killing of the time of the court.
Right, but see, you are in a 482 court.
Right.
How can I grant bail?
The first out, second out on the same day, it will be considered.
Right down. The petitioner, he is an accused in FIR number so and so, and section so and so, so and so. Although the petitioner's name was not mentioned in the FIR, but a charge sheet was filed against the petitioner on, charge sheet was filed on 9/1/2000 charge sheet.
2000. 2001.
Charge sheet filed 9/1/2001.
Yes, 9/1/2000.
9/1/2001 under section so and so, so and so.
Yes.
Page review first bar. There were as many as how many accused in charge sheet?
Charge sheet 11 accused persons.
As many as 11. Initially, first two accused, namely Yogi alias Ramesh and Bhagi alias Bhagwan, faced the trials. And the learned trial court on 21/6/2006 recorded an acquittal in their favor by evaluating the evidence. The relevant part of the judgment at para 12 reads as under. Para 12 लिख दो, para 12 and 13 at page 32. Page 32. ठीक है? Great. Subsequently, two more accused persons. Okay, জনে না দিয়ে না?
এটা দুইজন।
One more accused person,
জনে।
Nanda Porida.
Nanda
Also face the trial. The learned trial court by the order dated 27/11/2007 recorded an acquittal order in favor of Nanda Porida on the basis of evidence recorded.
Thereafter, 4 appeal.
5. Pancho.
41 page, but thereafter 5 also as the trial they have made.
And subsequent thereto, 5 accused persons, 41 so and so, have also faced the trial. And by judgment dated 27/11/2007, they were also acquitted.
Another accused, Dako Porida, is expired in the meantime.
One more accused,
Dako Porida.
Dako Porida, has since expired. The petitioner has been petitioner has been absconding since then. By way of the present petition seeks indulgence of this court and indulgence of this court and seeks quashing of the entire proceeding on the basis of the series of judgment passed vis-a-vis the co-accused persons. The reading of the judgment of the trial court in so far as the other accused persons indicates that the evidences recorded for those accused persons, and on the evaluation of the evidences, acquittal order was passed in their favor. Since the petitioner has been absconding, the trial could not proceed for him. At this stage, the petitioner seeks indulgence. For the petitioner at this stage submits that his client would be surrendering before the court and face the trial. However, some indulgence should be given to him in view of the fact that the case relates to an incident of 2000 and in between 8 accused have already been acquitted. Taking into consideration the aforementioned fact, the no indulgence is called for in so far as the present petition is concerned. However, the petitioner is given liberty to appear before the court on or before
within 2 weeks,
within 2 weeks, and avail his remedy under law. Or if any such application is moved by the petitioner, the same shall be considered on the same day. On its own merit. With this observation,
that will be disposed of the same day.
Same day, I have said same day. Because it is the sessions trial 302.
Another
first half, second half, no question of first half or second half. You go and
another summation I'm making. that the evidence was recorded on section 299. In that also, there no evidence is forthcoming against the petitioner.
All,
Only that
all
time.
right, in any case, you will go and get bail and face it. No
In
problem.
that case,
I have recorded everything, no problem. Okay, next.
Well, my lord, the petitioner prays for the quashing of the proceeding under 1cc case filed under section 138 of the NI Act.
You are the accused.
I am accused number 2 and 3. Accused number 1 is the drawer of the check.
Who are you?
But cognizance has been taken against all the accused persons.
Show me the complaint.
My lord, complaint petition. Check is at page 20. That is
Just show
drawn
me the
by
complaint. What
yes,
is
my
the
lord.
allegation?
Complaint petition is annexer
Yes,
4, my
I
lord,
got
page
it.
27.
Show me the complainant presented the
Page
what are the
27
allegations?
is
Number 1 issued the check. Accused number 1 issued the check.
My
Okay,
lord.
complaint letter so on the complaint sent to legal notice. Name of the accused form show. Right. There is complaint.
So far as check is concerned, the allegations are 9, 10, and 11. Clearly shows that the accused number 1 has given the check.
Yes. Documents provided for the accused number 1. The complainant found the land for which the check was given
My lord.
has already been leased out to accused number 2 and 3.
My lord. So
And
far as
further on the physical verification of the
on
property,
that
the
allegation,
complainant
yes, my lord.
found that the accused persons are peaceful position of
On that allegation, my lord, 138
138. It is simply sheet 138 or 420?
yes, my lord. Cognizance order is at page 38, my lord.
30.
38. That is annexer 5.
38.
Annexer 5, my lord.
Only one.
Order is at 39.
Issue notice to the opposite parties. Number 2. Oh, written with the show. The petitioners submits that admittedly the subject check was issued by the accused number 1, namely
Ramachandra
Sarma. Ramachandra Sarma. Insofar as the present petitioners are concerned, there is no allegation. There is no allegation in the complaint petition insofar as the offense under section 138 NI is concerned. Perusal of the complaint at para 3. Perusal of the complaint at para 3, page 38, para 3, which reads as under, indicates reproduction, indicates that the petitioners were the land subject for which the advance check was granted issued by the main accused. Main accused has been leased out leased out in favor of the present petition. Therefore, the present petitions were arrayed as accused. Issue notice kar do, in the meantime, the proceedings in 1cc case number 236 of 2020, qua the present petitioners shall remain paid. Yes. Yes.
No, this is for quashing a criminal proceeding, which had started because of a matrimonial dispute.
Yes.
Brief facts lyrics. The boy, let's some before your lordship,
Manas Tripathi,
as husband, had filed a divorce petition. wife had
I prefer quashing of the proceeding. You'll also kindly come to that annexure 1 at page 9.
9.
And the relevant page is page 10. Lordship, see here the informant before Lordship is the one, Subhasri Podiyaji, is working as MPHW, multi-purpose health worker female at
376.
Yes, yes,
294.
I'm coming to that one. You'll also see at page 10. Accused persons are 8 in number. All are co-workers working in the same office. And I am serial number 1, Sohail Akhtar. The matter I inquiry into.
8%, therefore 276, 2N.
Yes, you'll also see the matter was inquiry into, charge sheet was filed. Others were, there is no clue. So far I am concerned against Sohail Akhtar, charge sheet was filed at page 36, my lord. Investigation is completed. I submitted charge sheet, right, so and so. Then also come to that the 161 statement, page 38. May I place it, my lord?
Yes.
ମୋର ନାମ ଶୁଭଶ୍ରୀ ପଡ଼ିହାରୀ, ମୋର ଘର ଅଗରପଡ଼ା ଅନ୍ତର୍ଗତ ମହାନ୍ତିପଡ଼ା ଗ୍ରାମରେ ମୁଁ 2016 ମସିହାରୁ ୟୁନାନି ରିସର୍ଚ୍ଚ ସେଣ୍ଟରରେ ମଲ୍ଟିପର୍ପୋଜ ହେଲ୍ଥ ୱାର୍କର ଭାବେ କାମ କରୁଛି। Page 38.
That is FR.
161 statement of the victim, informant.
138 is in English.
Only page 38, madam.
38 in English.
No, 38 is different page, FR page.
Annexure 3.
Medical requisition.
No, that along with that charge sheet 161 statement is that.
1 minute.
Page 38, madam.
You are Mr.
Sohail Akhtar.
Sohail Akhtar.
Yes, madam.
38 is something else, sir. 38 is
Requisition for medical.
Oh,
Doctor survival.
then I am permitted to get
and
it.
you have something else, I have something
Yes,
else.
ma'am.
No, no.
So that
I am permitted to get it. Pagination properly
There
for
is
the
nothing in Oriya.
Yes, you'll also keep it this week in it. I will get it paginated, madam. Properly along with the.
It's not mismatching.
Yes,
Horribly mismatching.
I will get it paginated. According court filing.
Okay, next.
Well, my lord, I pray, my lord, let it come, my lord. If my lord, by mistake, the file has been placed in my senior's car.
You want an adjournment?
No, my lord, on 5th. No, by mistake.
No, you want an adjournment? Let it be adjourned.
No, 5th, my lord, by mistake.
Don't decide the date because
Kindly-
we have to.
I pray, my lord, I pray.
We'll see. Possibly we'll give it. Otherwise,
Or my lord, I
Very
pray,
difficult.
I beg apology for that. I file, let it come on 8th, 5 or 8th, my lord. By mistakenly file ta sarang sangre file ta padela by mistakenly.
your request is accepted. We'll give a date. Don't worry.
If there are 8,
There is waiting. Oh,
my lord. Okay. If there are,
he will adjust it. Don't worry. 8th or 5th or 8th, na? Don't have to accept it. You see that.
wait, please, your lord.
Which item, sir?
Well,
Item number?
next, this item, madam.
12.
13.
13, okay.
Well, I have challenged the order passed by Lord Magistrate in my lord dismissing my complaint and discharging the accused.
Who are you?
My lord, I am the complainant. Complainant, my lord, filed a petition of complaint, which was registered in the court of SDJM Khurda, my lord, which was registered as 1CC number 117 of 2023, my lord. So, my lord, the stamp reporter pointed out there are some mistakes which is to be corrected. The complainant found that the mistakes which has cropped up that cannot be corrected, and the fresh complaint is to be filed, for which, my lord, under Annexure 2, the complainant filed an application to withdraw the complaint to file a better application. My lord, may see Annexure 2,
Yes.
page 31.
Above named case, so amendment complaint may be permitted to
Withdraw the said case
withdraw
for
the
to unable to
said
remove the defects, hence liberty may be granted to file a fresh complaint
Okay.
by removing all the defects.
Then you file.
No, my lord. That was taken off on 5/12,
Okay.
and my complaint was dismissed. Withdrawal was not allowed, and order was passed under 245-2.
What does it say? Advocate for the complainant is present, peruse the office notes, and it is seen that
Last order has not been complied with. In fact, the learned counsel for the complainant has filed a memo citing reasons for withdrawal of the case and permission to file the case afresh. Peruse the memo. It is settled law that no order can be passed in this basis of a memo. Likewise, sufficient opportunity has already been provided to the learned counsel for the complainant to remove the defects as reflected in the office note. But it seems that he is playing hide and seek with the court and not complying with the earlier order. There is no provision in CRPC to allow for withdrawal.
Yes, that is that. As per except in a summons.
Except in a summon procedure case, but here the allegation to apply in the case warrant clear. So taking into consideration the above point and to like to invoke. What was the earlier order?
Earlier order, my lord, is
You filed it in on 15/11/2023.
ballot BC 1511, that is page 33.
Now, what are the
A complaint petition 420, 419, 466, 467, 468, 172, 125A, 33A of so and so. Advocate for the complainant is absent. Office note is ready. Defects found as complaint petition has neither filed with the proper documents relied upon nor has filed as per Rule 20 of GRCO, criminal so and so. Advocate for the complainant is present during the course of hearing and file document with a memo along with.
See, where is the legal bar for filing a response?
My lord, if 245(2) will be considered also.
No, whether you file it or not file it, I am not in. If somebody wants to withdraw with a liberty,
file a better application.
Can it be given? Yes, tell me.
My lord, as per order of the land court below, my lord.
No, he filed a complaint case.
Yes, ma'am.
There were some directions.
Yes,
comply this, comply that.
Yes, ma'am.
He has not filed what you call as per the procedure. Then he realized it and moved an application for withdrawing it, seeking liberty to file a fresh one. Whether you give liberty or don't give a liberty, something he wants his petition to be withdrawn. Where is the legal bar? Thereafter he files or not, that is his problem.
Of course, my lord.
Can't you allow him to withdraw also?
Right, my lord.
Right on. The petitioner is assailing order dated 5/12/2023, whereby his application dated 5/12/2023 inter alia seeking for withdrawal of his complaint case.
But to file a fresh complaint.
Complaint case has been turned down on next program. First, the petitioner initially on 15/11/2023 filed the complaint case. And the complaint case was found to be defective procedurally. And repeatedly directions were issued by the court to comply the office report and cure the defects. However, the complainant failed to cure the defect and eventually moved an application for seeking withdrawal of the complaint petition with the liberty to file a fresh one.
Yes.
The learned court below by the impugn order has rejected the said application. Stating inter alia stating that the court doesn't have jurisdiction to allow withdrawal of the complaint. I will not issue notice. I'll just set aside and I am of the considered view that the impugn order is not sustainable under law. The petitioner has all the rights to withdraw his complaint. Accordingly, his application seeking withdrawal of the complaint with the liberty to file a fresh one ought to have been allowed by the court below. Taking into consideration the aforementioned fact, the impugn order is set aside. The complaint filed by the petitioner, ICC case 117 of 2023, filed by the petitioner, stands withdrawn. And
the documents filed there
as per the prayer of the complainant before the court below, and the petitioner is given liberty to proceed in accordance with the
my lord, a small line prayer was there also to to give the documents which has been filed along with the complaint petition, so that I can file a better application.
In accordance with the law, I have said that you can move an application.
Otherwise, my lord,
necessary
court-
step, the petition may take necessary step.
Withdrawal of the
may
document.
move necessary step, application before the court.
To return all the
The petition further seeks the direction from this court that the documents he has filed along with the complaint case may be returned to him so that he can use those documents for filing a press one. Press one. Apparently, the trial court is direction, is directed to return the document they combined complaint replaced by photocopy. There.
My lord, may I submit one, may I interpret? My lord, lordship, which has been my senior has been read out. Your lordship may kindly have a seen that, and that there is no provision of the CRPC to allow for the withdrawal of a complainant case except in a summons procedure case. But here there is the allegation reflects a case under warrant procedure.
All right,
Okay.
let him withdraw and move application.
Okay, my lord.
Next court will see whether it should be
Yes,
entertained or not
only I have
entertained.
to brought before you.
I'll say that I have only said that in accordance with law it will be dealt by.
Yes.
He wants to withdraw, let him withdraw, let him do whatever.
Yes.
Yes, sir.
Obliged.
Senior is there, just ask him. Which check? Huh? Your item is
66.
66. Is there anybody appearing?
The vigilance.
Vigilance. 66, I think vigilance is Ms. Marana. But Marana was there. In this matter, Ms. Marana. Because Ms. Marana is not very, that's we say.
My item is also 65. Mr. Varana also requested me.
Yes, that I am urgent. If Ms. Marana is there, then your matter will be urgent. He is not well.
Yes, sir. But ठीक है चलो ना things about I don't
Then
know.
let us wait.
Sir, it's a open and short case.
But let us see who is there, right? Yes.
Let it be and some other time.
Maybe Ms. Morana may.
Yeah, of course. But the council is unwell.
It's not well. Really. After some good time.
NBW issued on 6/10/2023.
Yes.
And he was on bail on 27/3/2014.
27/3?
2014.
Okay, 500. Yes.
17.
May I please? Our matter has been compromised, my lord, and joint affidavit has already been filed.
What is the offense?
294/506/34. That is section 3 and 4 of the.
What are the allegations?
Allegation is that
Yes, there are 8 accused.
my lord, there are 18 accused, my lord.
18 accused.
my lord.
What are the allegations?
That in a village dispute, the
ସେ ଆଜି ଜୀବନରେ ମାରିଦେବାକୁ
ଆଜ୍ଞା।
କହି ହାତରେ ରଖିଥିବା ବୋମାରେ
ଆଜ୍ଞା।
ମୋର ଉପରକୁ
ହାତରେ ଧରିଥିବା ବୋମା ମୋ ଉପରକୁ ଫିଙ୍ଗିଲା, ମୋ ପାଖରେ ପଡିବାରୁ ମୁଁ ବଞ୍ଚିଗଲି ଓ ଅନ୍ୟାନ୍ୟ ଆସାମୀ ଧରିଥିବା ବାଡି ଠେଙ୍ଗାରେ ମତେ ଘୋଡେଇଲେ।
What is the stage of the investigation?
Investigation has been completed.
Charge sheet?
Charge sheet filed.
Where is the charge sheet?
Lordship में
Yes, Mr. Rahul, have you seen any legal impediment?
there is no injury, nothing, my lord. I have also given all the injury. There is no injury. Absolutely.
Charge sheet you have filed?
The charge sheet is there. Will you see it? All the accused persons are there.
Only 2 have come before my lordship.
Why?
Rest they are not.
You call them. You place it on the court. Call them.
My lord.
You have to. They will have to be there.
2 have filed.
They have time to go and hurl a bomb, but they don't want to come to the court.
2 of them has compromised.
But it's all right. Only 2 of them have compromised.
Yes.
What about the other?
Others have, they don't have in a mood to compromise the accused persons.
Against these 2, what are the allegations? That has to be seen.
Yes.
Give a copy to him. Put it next week. Give the copy of the charge sheet to him.
The parties are present.
Let them be. The present the petitioners are accused in FIR number so and so. Along with how many accused in charge sheet?
Charge sheet, my lord.
Along with 16 others, 18.
No, my lord. But charge sheeted accused is 9, my lord.
9.
9.
Along with 2 jana file korchindi na?
My lord.
2 jana file korchindi. Along with 7 other accused. The petitioners submits that they have settled the dispute with opposite party number 2. Opposite party. Where is the opposite party number 2?
They have come.
The petitioners and opposite party number 2 have filed a joint affidavit, which is taken on record. Taken on record. Mr. Rahul submits that since the charge sheet is filed, he would be examining the role of these witnesses.
Present petitioner.
Present petitioners.
Omnibus allegation.
Present 2 petitioner. He has a present petitioner and present 2 petitioners. To ascertain whether there is any legal impediment in quashing the FIR qua these petitioners or not. At least the matter of fact. And the petitioners and opposite party number 2 are present in the court. Present in the court today. Okay, next week video.
On that day, they will appear again, my lord.
Let them appear.
Huh?
Let them appear. What is it?
Yes, yes.
Let them appear. ଆପଣ ଟିକେ ଦେଖି ଦିଅନ୍ତୁ ଏମାନଙ୍କ ଆଗରେ ତ କିଛି ନାହିଁ will quash it. Quash it.
Lordship may fix a date, man. 10th.
What about the other? Because these people have paid the money.
No, my lord. They have compromised. Other people are working outside. They are all, my lord, labor class people.
Cannot say that they have compromised in respect of 2 accused persons.
That's the whole difference.
He has to say, I have compromised the matter with regards to all the accused persons.
Because then it appears that he has taken some consideration from them,
Yes.
and the other people might not be
That
getting,
is not a
and this
part of
situation may be there. So
No. What happened in this case? I am appearing for the opposite party. The opposite party is the informant in this case, your lordship. What I have taken instruction, there was village meeting. Other accused persons were remain present. At the time of filing the present CRLMC application, they are not ready to be for my lord. Only 2 petitioners are there.
the accused persons are not ready.
Yes, your lordship. That's why I am submitting. Only 2 accused were there. That's why my lord senior have filed only 2 petitions.
Why accused persons were not ready?
That is
They are happy to face the trial.
He will also
They are all around bail.
pass the order and free copy be given.
I have also called the
IAC
other parties are.
In this regard, Mr. Rahul may seek instruction from the concerned IAC, and please report before this court in the next day.
Lordship may keep it to 12th, madam.
12.
12th.
The meeting
Yes.
My lord, I may be permitted to withdraw.
Withdraw. Give the memo. Withdraw. Yes. Next.
19.
May I please, Your Honor? May I please, Your Honor?
Yes.
In this case, the petitioner is alleged to have committed an offense punishable under section 354, 354A, 323, 506 of IPC. And the case was.
What do you want? You want cancellation of NBW?
Yes, my lord.
You are on bail?
Yes, my lord.
You tell me the date when you got the
bail on by
right on 22/12/2016.
2016, my lord.
Granted by this court while allowing ABPL number 20241 of 2016. Okay. And he remain absent on 13/12/2022. Okay. Cancellation. You give 500 rupees cost.
Obliged, my lord.
Yes.
20.
May I please, Lordship? I'm challenging the NBW order of dated 18/1/2023, Lordships.
Bail.
Here the petitioner is released on served on notice on 41A on CRPC, my lord, on dated 8/2/2015.
Petitioner got notice under section 41 on
8/2/2015.
8/2/2015. However, after filing of charge sheet, he remain absent from the court, leading to issuance of NBW dated
18/1/2023.
18/1/2023. 500.
21.
Obliged.
Yes.
May I please, your lordship? Belgium matter on dated 26/9/2016 NBW issue 9/12/2015 he was bail.
9/12/2015. 1000. Yes.
Obliged.
May I please, your lordship?
What is the date? Today is
April 2nd.
Second, na?
Yes.
30th crore.
30th crore.
30th.
Yes, sir. 30th.
Honor report.
May I please, lordship? It's a Belgium matter. In that case, your lordship, I'm previously
Police bail.
Police.
regarding
Yes.
that, your lordship, running page 27.
Petitioner was on bail, defaulted in appearance, and 28/11/23. Okay, carefully review. Number order. Okay, 500. Yes. Next.
23.
Lordship, 23
Obliged.
Where the passing order is 4/5/2023. NBW was issued, my lord, and he is on bail on order dated 7/6/1999.
99. What are you doing? 99 matter still pending. Okay. One. Date NBW dated
4/5/2023.
500. 99 ना आगो कर दो 15. Make it 15 in this case. On or before 15th you appear because it's 99 matter.
24.
24, my lord. NBW was issued on 6/7/2018 and bail, he was released on bail on 28/7/2016. Annexure 1, page 10.
1000.
25.
NBW issued on 31st October 2023 due to his absence. But on that day, he was before the Honorable Court of Judicial Magistrate, Chief Judicial Magistrate Jagat Singhpur.
You are on bail?
I was on bail since 24/11/2022.
ठीक है NBW 3
I was on the before another court, so that I couldn't appear.
500. Okay. Next.
56. 56.
NBW.
नहीं এটা কক কু চ্যালেঞ্জ
Okay, pass over.
Yes,
Next.
pass.
27.
My lord, NBW was issued on 1/7/2019, page 14,
Hmm.
and he was released on bail on 17/11/2014, page 10.
Oh, seven people.
Yes, ma'am.
Huh?
Yes, ma'am.
7 people. NBW issued on 19.
1/7/2019.
1,000 each. That's the standard. If it is the 2019, then what to do?
500.
7 people.
500 each.
To bar. Bar needs money.
Yes.
Your clients are capable of paying or not?
That
That also has to be seen. Otherwise, unnecessary.
5,000 all total, ma'am.
5,000 in total. Huh?
Total, yes.
Yes,
Total.
yes.
28.
Ma'am. The NBW was issued on 26/2/2024, page 11, and bail was granted on 6/1/2018.
Here, 6-1
2018 bail
for
was
all,
granted.
all of them.
All
All
of them.
4.
All four.
All 4.
Yes, ma'am. Pay Annexure 3, page 70.
Right. Bail granted on
6/1/2018.
okay. NBW on
NBW was issued on 26/2/2024.
500 each. 500 each.
24, ma'am.
500 each.
Yes, ma'am.
500.
Yes.
29.
Then once the applications become infructuous.
Infructuous.
My lords.
Let counter the petition submits that the petition has become infructuous. Dismiss as infructuous.
30.
Pass over.
31.
31. You are there? Pass over.
32.
My lord, in this case, I am challenging the order annexure 2, annexure 1.
Yes.
In a NIACT case, in this case, the Lord and Magistrate rejected the 205 petition, and that has been allowed by this your lordship, and thereafter on this next day the Lord and Magistrate directed to the petitioner for personal appearance for framing of charge in a NIACT case.
Which order is that?
17-10 page number 6.
17-10
22.
Advocate over the accused files. You are for accused.
My lord.
Offense under
138 NIACT.
So what is your grievance?
My lord, in NIACT case, the personal appearance for framing charge is not necessary. Framing of charge is not necessary.
Explain the charge of the accused. Advocate directed to physically presented the same advocate for the accused physically absent on previous 2 days. Or neither your lawyer is appearing, nor you are appearing 138.
Liar?
No,
Liar?
that is the recording.
No, my
The-
lord,
just
the record is
Advocate directed to physically present in the accused sale.
Accused.
Advocate for the accused is repeatedly absent on
No,
previous 2
repeatedly
days
absent.
and orally submitted.
repeatedly absent, orally submitted. This is the order. Orally submitted
You
the.
don't go, how to do? Go.
My lord, the order. I am orally submitted. The necessary of accused is not required for framing of charge. This is the.
What is the big deal? Why can't you appear once? Why can't you appear once?
My
Framing of charges.
lord, the history of the case, the Lord Master rejected the 205 value, 205 petition, and that has been allowed by your lordship. On the next day, the Lord Master, this is not the submission. କାହିଁକି ସେ ଆସିବନି ଆମେ ଏଠି ବସି ଯାହା କରିବୁ ସେଠି କରିବୁ
charge frame of present charge.
ଗୋଟେ ଦିନ ଯାଆନ୍ତୁ କଣ ହେଇବ?
ଯିବ charge frame.
Why are you getting into ego? ठीक है କେବେ appear କହୁନାହାନ୍ତି? By the impugn order, the learned court below has directed the petitioner, being the accused in a proceeding under 138 NI Act, to appear appear physically on the date when the charge is to be framed. Charge is to be framed. Then comes for the petitioner submits that in a proceeding under 138 NI Act, the physical presence of the petitioner ought not to have been insisted upon. Ought not to have been insisted upon. The perusal of the impugn order indicates that in the previous 2 dates before the court below, even the lawyer was not present, and lawyer is not present, and the then court below has directed the petitioner, being the accused, to appear physically for the purpose of framing up charges. Framing up charge against him. Then comes for the petitioner submits that he has no issue in appearing before the court at the time of framing up charge. However, his application under section 205 CRPC needs to be decided by the court below afresh.
The prisoner was allowed. Prisoner was allowed.
Allowed, and no issue appearing. Charge, and then how charge as his application under section 205 CRPC has already been allowed. In the foregoing, in the foregoing, let the petitioner appear before the court on or before on or before 30th of this month. This month for the purpose of charge, framing of charge. For the purpose of framing of charge, isn't it?
Yes,
For framing of charge, on the framing of charge. Okay. Next date of hearing you have? Do you have next date of hearing? When the date?
No, my lord. No, my lord. Till that, no coercive action taken.
What coercive action? Who will take coercive action?
BW issue.
BW
issue.
No
coercive action.
BW, the bailable warrant against bailable warrant issued against the petitioner shall kept in events till 30th of April. Till 30th of April. Till 30th.
22 ମସିହାର ଏଟା ତାପରେ ଏନୁଲ ହେଇଥିବ କଣ ହେଇଥିବ ସେ ଜାଣିନି
30th April to enable the petitioner to appear before the court.
Subsequent ତାପରେ କାଳେ ଏନବିଡବ୍ଲ୍ୟୁ ହେଇଥିବ ସେଇଠୁ
ठीक है ଆପଣ ବି ରହନ୍ତୁ ହେଇଲା dispose of yes 30 password 34 yes
Only praying for next week also.
urgent 35 36 ये adjournment मांगते हैं नहीं password 37 38 अच्छा बेटा अर्जन है 38 next 39 40
My pleasure, my lord.
40
Here in this case, my lord, on the same fact, my lord, 9 FIR has been registered.
9 FIR
against the one co-accused person, Rasa Ananda Kalasa, and against the petitioner 2 cases. Facts means that same informant, allegation is that on the very same day, while they are, my lord, getting information regarding the transportation of laterite stone, they took 2 witnesses, say Ashish Kumar Barik and Ramesh Chandra Barik, and thereafter found that all my lord, the petitioner and the co-accused person are operating the quarry. No person was apprehended from the spot, my lord. And As on this, and this honorable court, while my lord hearing the application for other co-accused for Rosananda Kalasa, first for the first
Investigation is still going on.
yes, for 9 cases.
He has also let it be 10 cases.
Yes, no, your lordship can see. On the same case for the co-accused person, this honorable court for the first instance, here all these application 9 cases and dispose of first instance issue notice and how my lord on the basis of TT Antony and state of Kerala on the same affair, multiple affair cannot be registered. Same fact, same time, same witness. That while the
police will close it, but you
on that light, my lord, this honorable court.
My lord, I beg pardon. My lord, I beg pardon. The item number 41 also this same.
Your lordship kindly see. FIR same.
And there are 80 criminals antecedents of nature.
8, 9,
ଶୁଣ ଆଠଟି ଅଛି ଆପଣଙ୍କର ଗୋଟିଏ ଥାନାରେ ଆଉ ଦୁଇଟି ଖୋର୍ଦ୍ଧା ଥାନାରେ ଅଛି।
No, my lord, in the FIR it has been clearly mentioned to against the co-accused person.
This is Rosananda.
Rosananda, I am not Rosananda, I am Vikram Rajana.
How many cases?
Only 2 cases that has been reflected in the FIR, my lord. Against whom, my lord, be 9 cases are pending, but against the present petition only 2 cases. That is, my lord, against.
And this Rosananda is also accused in all these cases.
All these cases that dispose of this of the same affair, same allegation, same witness, pick up to witness, same area puni, Baraghar Patna area. While they are, my lord, investigating the matter, they are found that some accused persons are operating the quarry. Same allegations. All these 9 affair. That's why this honorable court tag all these cases. And at the first instant issued notice, and thereafter, my lord, dispose of all these applications with these observations.
At least this is not covered by CT Antony case.
Same order, I'll do it. You go and tell the investigating officer.
And
that's what it says. That's what it says.
Yes, my lord. But
41, 42.
41, 42. But in that case, my lord, interim order was granted, no coercive action.
No, I'm disposing up. While issuing notice, interim order. Now it is disposed up. It only says, just see, in view of the above matter, criminal MCs are disposed of with a direction to the investigating officer to take note of the contention raised by the petitioner, stated in the position of law, law laid down by TT.
And I'll
41, 42 dispose of in terms of
and my lord,
41. You have invited. Why should I issue notice, sir?
I will cooperate. My warrant has been so feel, my lord, that
you are relied upon this. In terms of this, I am allowing your petition.
40, 41. And your lordship, my small pair.
What else you need? I am allowing your petition in total.
Because my lord, here in this case, I want to cooperate. So unless I will cooperate, my lord, because my lord, till my lord,
I'll write down.
I will produce. Till
I'll write down. You are going to cooperate.
And until my lord, I will cooperate.
482, sir.
482.
430 rejected.
No, 430. Samathankar se haitila. That's why therefore.
A order mote dekhi diyantu. A order court lekhai. You are relying upon this order. Exactly the same order I'm going to pass.
My lord, in that case,
why this is not given?
Now the development is now warrant has been issued against the petition. That's why my lord, I will cooperate with the investigation and produce all my lord.
Let counsel for the 40-41. Let counsel for the petitioner submits that for the on the self same allegation. 2 FIRs have been registered against
the present petition.
Against the present petition. And full sir. Co-accused in the opposite to FIR. First petitioner is accused in FIR so and so and so and so. First paragraph, second FIR. Namely Rosananda Kalsa had approached this court by filing CRLMC 1452 of 2023 and all this. The co-accused Rosananda Kalsa contended that 9 cases have been registered against him for self-same cause of action. Self-cause. Next one. The petitioner is also similarly situated. 2 cases have been registered against him on the allegation of on the self-same allegation. Self-same allegation. Counsel for the petitioner seeks similar direction as has been passed by the coordinate bench. Coordinate bench in CRLMC 1452 of 23 and batch. Taking into consideration the similarity between the facts of both the cases, I am of the consideration that the petitioner is entitled for the same relief as has been granted to the co-accused Rasananda Kalsa. Accordingly, the CRLMCs, CRLMCs are disposed of with a direction to the investigating officer to take note of the contention raised by the petitioner as stated above. Petitioner, and also take into consideration the provisions of law laid down by the Honorable Supreme Court in T.T. Anthony versus State of Kerala, reported in 2001, 6 SCC 181. Let counsel for the petitioner further submits that coercive action has already been taken by the IO of the case. Therefore, he seeks further in the case. Further on his second petitioner submits that he will be appearing before the IO on or before 20th of April and apprise the and cooperate with the he shall also avail remedy under law. Remedy under
My lord, that till 20, my lord, that no till 20, my lord, I will feel that
obviously I've said that he will honor you for you. Yes. Both 40, 41, 42. 40, 41.
41.
Yes.
May pardon that. Item 39, I'm sorry, I bought the wrong file. You'll see. Pass it over. I paid for next week. I bought the wrong file.
39 urgent. Yes. 42.
My lord, 42 pass over.
Pass over. Yes. 43. Pass over. 43. Are you there? Yes.
My lord, may I please?
Yes.
Petitioner is challenging the criminal proceeding, my lord. Offense under section FR was lodged under section 493, 417, 4323, 506 and 34.
Yes.
Copy.
No case of 376 murdered, my lord. As per 20.
That sheet is filed.
Yes, my lord.
Cognizance is taken.
Yes,
If
my
no
lord.
case is made out, then
Page
you argue that
24,
on
my
at
my
the
lord,
time of
kindly
framing of
see
charge.
Page 24, my lord. kindly see.
24. Okay. Let us see. 24.
Read it.
Okay. Come to page 24. Yes. Come to page 30. 30. Read 30. Mona Rukmani Harijan. 21 ବର୍ଷ ପିତା ଶୁଣନ୍ତୁ ବରିଗମା ଜିଲ୍ଲା ଆଜି 3 ତାରିଖରେ ଥାନା ବାବୁଙ୍କ ନିକଟରେ ମୁଁ ପ୍ରାୟ
24, my lord. ମୋ
ଦେଢ଼
ନାମ
ବର୍ଷ
ରୁକ୍ମଣୀ
ହେବ
ହରିଜନ।
କୋରାପୁଟ ନିକଟରେ ଗ୍ରାମରେ ଅଛି ପଦନ ମୁଁ ଭଲ ପାଇ ଆସିଥିଲି ଏହି ମୋବାଇଲରେ କଥାବାର୍ତ୍ତା କରେ ସେ ମୋତେ ସବୁବେଳେ ବିବାହ କରିବେ ତେଣୁ ମତେ ବରିମା ଦେଇ ତେଣୁ ମତେ ଡାକିବାକୁ ମୁଁ ଘରୁ ବାହାରି ଯାଇ ବରିମା ଦେଇ ସମ୍ପର୍କୀୟ ମାମୁଁ ଘରେ ତୋଟାଗୁଡାରେ ଯାଇ ନିଜେ ଏକାଠି ସ୍ୱାମୀ ସ୍ତ୍ରୀ ପଡ଼ି ରହିଛି। ସେଠାରେ 5 ଦିନ ରହିଲା ପରେ ଛବି ବା ବାପା ଘରେ ଯାଇ ରହିଲି। ଏଠି ତାର ପରିବାର ଲୋକମାନେ ତାର ବାପା ମାରାମାରି Here, the allegations are there.
My lord,
Allegations are there. It may not be 376.
yes, false
but
promise of marriage, my lord.
The allegations are they were in love relationship.
My lord.
She went of her own free will, and they stayed like wife and husband for some time. They shifted to different place. They came back to the town, and this boy said that I'll recharge the mobile, and went away. So that is the case. What she is apparently saying is there is no 376. If that is the case, it is cognizance stage. I am giving you liberty. Go and argue before the charge court. That charge will be dropped. That charge will be dropped.
Come after charge.
Right now. Counsel for the petitioner and in the present petition is challenging the order dated. Order dated. Cognizance order. Where is that? Order dated 12/9/2020. To 12/9/2020 cognizance is taken. Charges might have been framed now.
यदि चार्ज फ्रेम है तो चार्ज फ्रेम पर आसवा
Charge frame is 8
पर आसवा
4 years. Do you have any idea? No idea.
चार्ज है कि नहीं जानते देखिए
Charge is 8 again. I give liberty. It's no meaning. You get the instruction. You must have instruction, full instruction, because you are challenging the order dated 12/9/2020. We are in 24. Charge might have been framed now, and trial must be going on.
Will take instruction, my lord.
Take instruction. In the present petition, petitioner is assailing order dated 12/9/2020, wherein charges under section so and so, under section page number 34, and so cognizance for offence under section so and so has been taken against the petitioner. Counsel for the petitioner seeks time to seek instruction regarding the status of the trial in the present case, adjourned to forget that. Yes. 44.
May I please, your lordship? My lord, challenging the entire criminal proceeding on the basis of the amicably settled between the parties. The informant and
What are the allegations?
allegation are, my lord, 294, 506, 354 A and C and SC/ST Act.
Where are they? Neither accused nor the informant. Where are they?
No, my lord, they have not appeared.
Bring them.
My lord.
Next week. Bring them. Next
My
week.
lord.
Yes. 45.
Obliged.
45.
Scan class running page 16, lordship.
16.
Lordship, 16.
Hmm.
Lordship, the petition is challenging the order dated 24/12/2022 of the Lord STGM Manjanagar in a 2B6 case to the extent of confiscation of the seized vehicle. To the extent of confiscation of the seized vehicle. Here, lordship, the case has been initiated by the Forest Department against the petitioner and another person. The vehicle of the petitioner has been seized by the forest personnel.
Where is the order of 24/12/2022?
Lordship, here is running by 16, lordship.
16.
Lordship.
You are agreed by this order?
Lordship.
Tell me what is this order?
The prosecution has withdrawn the case initiated against the petitioner, but here, lordship, the last portion, lordship, there is a direction to confiscated to the government after expiration. Here, lordship, in the last line.
These articles is confiscated to the government
After the expiry of
After
appeal
expiry of the
period,
appeal period.
if no appeal is
If no
preferred,
appeal is preferred.
if preferred, then the same shall be dealt with as per the direction of the Honorable Appellate Court.
What is wrong in it?
No, yeah, I'm challenging that portion here, Lordship.
Why?
Lordship, kindly glance at top of the order, Lordship. Top.
Right.
The
The
Lordship,
case
got it.
record is put
They
up
are-
today.
put up today on filing of the petition under section 321 of CRPC by the prosecution through the learned APP with a prayer to withdrawal of this case on the ground stated therein. Period the said petition where the learned APP submitted that the Directorate of Public Prosecution Odisha has directed to withdrawal of the prosecution pertaining to peer in view of letter number so and so, dated so and so, of the petty forest offense cases pending as on September.
You don't know the informant who is the informant?
Here, informant is the forest personnel. They have seized my vehicle. Later on, they will withdraw the complaint.
Yes.
Then, my lord, he may be go to the appeal, my lord.
No, appeal that.
No, what he says is there was a prosecution launched by the forest department.
Yes, my lord.
And the forest department has now moved under application under 321, saying that we want to withdraw the prosecution against the petitioner. If you withdraw the prosecution, then where is the question of appeal and all? Just see last paragraph. The seized article is confiscated to the government after the expiry of appeal period, if no such appeal is preferred. There is no question of appeal because there is no separate informant. Who will file appeal?
In investigation, my lord.
So just check it up, the prosecution. This is a formal order, just copy paste order. This has to go. You have withdrawn the prosecution. If you have withdrawn the prosecution, give it back. Why are you withdrawing?
I may be taking instruction, my lord.
What instruction I'll
Yeah, your lordship.
Why to? I'll dispute. Prosecution under section?
Under section, Lordship.
People have none. That's the whole difficulty. You don't file anything.
Lordship.
Where is the
Rule,
complaint?
rule 4, 12, 13 and 20 of OTT rules.
Where will I get those things?
Running page 7, Lordship. I filed the prosecution report, Lordship.
complaint
Running page
case?
7.
Huh?
Running page 7.
7?
Lordship.
Okay. This is, what is this? This is offense report.
Offense report of what?
Forest department, huh?
Lordship.
Where is the offenses?
Offenses, Lordship, here, Lordship. The offense of sections of the Forest Act and Indian Penal Code.
Where are you reading?
And the last line, 1, 2, 3, 4, fourth line of the nature of offense.
Place of occurrence?
Nature of offense.
Nature of offense.
Offense. That's all fourth line ଅଛି.
कहाँ कोडी पढुଛନ୍ତି ଆପଣ?
Fifth line, my lord, by written.
Page 7.
Page 7, Lord.
Fifth line, place of occurrence.
Under section 56.
And okay,
56 of
reference to the sections of the Forest Act and Indian Penal Code. Under section 56 of Forest Act. 1972 amended and rule 4, 12, 13 and 21 of OTTR rule. And what was seized?
This is the scooty, Lord. Running page 11.
Write down.
Running page 11, Lord.
Petitioner is assailing the order dated. Petitioner is an accused. A prosecution was launched against the petitioner under section 56 of Forest Act 1972 and rule 4, 12, 13 and 21 of OTTR 1980. During the investigation of the said case, what was seized? Where is the seizure report?
Seizure, that is, let's see.
A scooty bearing number?
Running page 11.
Bearing number
Honda Activa scooty number.
Activa scooty bearing number?
OD 323665.
3365. OD 323665.
Yes.
Was seized from the petitioner, from the petitioner. While the next paragraph, while the matter stood thus, the
Lordship is
prosecution-
going to dispose of. Lordship is
Yes.
going to dispose of.
Yes.
Lordship, one instruction should have been given. One date, your Lordship.
Whether earlier manner the confiscation disposal of or prosecution withdrawal manner, that is the
The ballot
question.
test order sheet
reflect
ତାହେଲେ ସେଟା ଯୋଉ period of limitation ରେ ଆମର withdraw ହେଇଥିବ. Period of limitation ସେମାନେ appeal prefer କଲେନି. ତ
He appeal karibo, prosecution, you
Against
have withdrawn.
given na.
He will not go for.
Against the confiscation, he has to prefer the appeal manner.
Appeal.
Before the.
No, there is no confiscation.
ତାଙ୍କ
There is no
ସେଇ
confiscation.
order portion ଟା ସେ ପଢିଥିଲେ.
ସେଟା ସେୟା ନୁହଁ ଅର୍ଡରଟା
no
ଦେଖୁନାହାନ୍ତି
confiscation
ଆରେ ସେଇ order ଟା ଦେଖୁନା ତମେ ଯୋଉଟା
ମୁଁ ଅର୍ଡରଟା ପ୍ଲେସ୍ କଲି ଆପଣ ଦେଖୁନାହାନ୍ତି
The basis goes, everything goes. If the prosecution goes, where is the confiscation? You have withdrawn the prosecution.
ନା ନା ସେଟା ନୁହଁ.
Withdrawal the confiscation ହେଇଥିବ.
On further page of
ସେଟା ନୁହଁ.
321 CRPC.
ସେ ଯୋଉଟା ପଢୁଥିଲେ first ଟା.
ସେଇଟା ସେଇ କଥା ନୁହେଁ
ସେ order ଟା କହୁନାହାନ୍ତି ଆପଣ.
ତେଣୁ ଅର୍ଡରଟା ମୁଁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛୁ କାହିଁକି
One or more offenses and try to report.
କୋଉ first order ଟା ଦେଖେଇଥିଲେ ସେ ପଢୁଥିଲେ ଯୋଉ first order.
Discharge and-
Order attach କରୁଛନ୍ତି ଗୋଟେ.
The accused is discharged, sir. Discharged under 321 small a. Once the accused is discharged on the basis of the application moved by you and the basis goes, so confiscation also goes.
Prior to that, whether the confiscation proceeding.
How will you sustain confiscation if you withdraw the?
That has disposed of my lord, by the confiscation authority my lord. Then is he has to.
Where is
prefer
that?
appeal, my lord.
Nothing is there.
Set
I will
that
write down
form.
subject to confiscation proceeding.
ଯଦି
Appeal under section.
ଯଦି dispose ହେଇଥିବ ବାର ବାର limitation ତାଙ୍କର ହେଇଥିବ appeal କରିନଥିବେ ସେଇଟା ଫାଇଲ କରିଥିବେ
ସେଇଟା ସେଟା separate issue ଟା
But
magistrate
no, whatever, but they say if there is a confiscation order, if there is a confiscation order,
he has to prefer
subject
appeal.
to that appeal,
appeal କରିବେ ଯଦି appeal period ଅଛି read file କରିବେ
I'll record it.
My lord.
You are submitting.
Yes.
Write down.
କଣ ଗୋଟେ ସ୍କୁଟିରେ ଆପଣ କେସ୍ ଆପଣ ଉଡ୍ର କରୁଛନ୍ତି
Good that.
ପାଞ୍ଚ
The
ଜଣ ଠିଆ ହେଇ କହିଲେ
prosecution
ହବ
moved an application under section 321 of CRPC seeking withdrawal of through the prosecutor for withdrawal of the prosecution against the petitioner, The learned court below, wide order dated 24/12/2022 allowed the application of the prosecutor and discharge the petitioner from the offences under section 321 bracket small a of CRPC. Discharging petitioner, following of the page 16 last paragraph to the paragraph. The next paragraph. The petitioner is agreed by the aforementioned of the division. He submits that since the entire prosecution has been withdrawn and he has been discharged from the offences, the siege article should have been released in his favor. Mr. Rahul, land counsel for the state, submits that the petition is not clear as to whether there was a confiscation proceeding initiated against the petitioner or not. Therefore, the last part of the order is justified in view of the fact that the release of the vehicle could only be possible after the appeal period after the appeal period is lapsed insofar as confiscation proceedings are concerned. taking into consideration the aforementioned submission at the bar, I am of the considered view that the impugn order dated 24/2/2022 passed by the STJM Panjanagar in 2B CC number 18 of 2016 is liable to be set aside. Last part of the impugn order, as mentioned above, is liable to be set aside, subject to the condition that subject to the condition that the period of appeal in the confiscation proceeding has already this is the confiscation. It is 2016 matter, huh? 2017 matter.
Data proceeding कौन है किसी ना किसी अन्य करना.
With aforementioned observation, the petition is disposed. Okay.
56. 56 already executing for you.
Yes.
46 have already allowed the writ application, CRLMC. My lords, it was directed that the passport be released. My lords, only thing in the order that I seek for clarification.
Taking into consideration the aforementioned submission.
Yes, my lords. Is directed to release the passport to the petitioner so as to enable him to apply for renewal of the same. My lords, the passport authorities are saying if there is a clarification from this court for a period of 10 years, because my lords, the passport is renewed for 10 years. But what happens? The OPID code goes on imposing conditions 1 year, 2 years. So if it is
for the purpose of confiscation only.
My lords, because he plans to travel to US. So for a period
for visa is 10 years. Passport is 5 years.
Passport is 5 years.
Visa only 10 years. Visa I can't pass directly.
No, your lordship. For 10 years, 5 years. No.
How can I pass an order for 10 years?
5 years.
Visa is only 5
years. Passport is 5 years.
For a minor, it is for 3 years. For major, it is for 5 years.
Major is 5 years. For 5 years.
Obviously, they will do it for 5 years by the under the act. They will do it.
Yes,
they can't do it less than that. Then what clarification I can give?
They are saying that they need a clarification.
Where is that?
When we went for appointment for renewal of passport, they are saying it is only there's an order for renewal.
Renewal has to be for 5 years.
In accordance with law.
They can't do anything else.
I understand, Balas. That's what I was telling him, that it can be.
Had it been a visa case, then for American visa, 10 years visa.
Yes, American visa.
No court can give direction for visa. Okay. Then for renewal purpose, once you apply for renewal, it is always for 5 years.
5 years.
Where is the direction required for that?
In accordance with law.
Where is your application?
IA we have filed 714 of 24.
714. Where do you say that the authority is saying, taking into consideration ticket? Where do you say the petitioner is filed in such application for modification of order that are most submitted that the petitioner pays for designated for OPID for release of the passport for the purpose of renewal for a period of 10 years? How can this application be allowed?
No, my lords.
Because you are an accused, so you have special preference, 10 years. No, normal citizen will get 5 years because you are an accused in OPID case, so 10 years. 5 years. That kind of application you moved, it will be rejected only. Simply withdraw it. Why to complicate it?
In accordance
with anything else.
In accordance with law.
Simply withdraw it. If any problem, you come. If I pass some order again, it's complication.
Again. Yes.
Then counsel for the I will record it.
Yes.
Simply Mr. Kanungo or counsel for the petition seeks to withdraw the application to avail the benefit of the order of this court dated 7/2/2024 and apply for renewal of passport as per
Needless to say, they will renew it as per.
Needless to say that in case the petitioner apply for renewal of his passport, the same shall be dealt with in accordance with law.
Deeply.
After renewal, you will submit before the.
That is there.
No, that is there.
That is there.
Submit.
Renewal doesn't mean that he will go. Obviously, he has to surrender and take permission.
Deeply.
47. Please, Madam, PCP Act. And
47, huh?
37. And petition has challenged the
47. Okay. Yes.
petition has challenged the compliance order.
Yes.
11/2030. But in the Tahsildar cum executive magistrate has has filed a case and investigated the matter.
What is this taking
PCP Act.
To visit the petition was the discourse upon court including bench of the court rights. Yes, what do you want?
That's it, or cognizance order. On the grounds that it is delayed, it is 11 years delayed. Apart from that,
What is the stage of the trial now? Charge has been framed.
My lord, I'm submitting that the present status. Present status, it has not moved. It is still in here.
The last order on 26/12/2024.
Yes.
I have passed this order, reiterating the same time the petitioner has again filed the present petition. It is surprising that even though the cognizance was taken in this matter on 30th November 2013, there is no progress in the trial. The counsel for the petitioner submits that the charges has not yet been framed. Maharaja counsel for seeks time to seek instruction in this regard.
On the last provision, I also said that it is still is of status of PA.
My lord, earlier, but CRLMC 6347, my lord.
Yes, ma'am.
Act 2014.
See, you read that order, everything I have written.
That has not been complained.
Why the charge has not been framed so far?
My lord,
This is arising out of CC case, huh?
yes, ma'am. Cases in the status of
You have taken stay, what to do?
no, my lord, 2-3 dates have been there. Other than that, every state has not taken any interest in disposing.
You have taken, who has taken the stay? You have taken the stay.
Stay for 2-3 occasions. 2-3
What
days.
is true? No. Just see, you have taken a stay on 15, 12/1/2015. This is the counsel for the petition file Hajara. He also files a copy of order dated 7/1/2015 and so the Honorable High Court directing further proceeding and CCTV pending is stayed. Thereafter, waiting for intimation from the High Court 2016, 2016 khatam, 2017 khatam, 17, 18 also, 19 also, no intimation, 18, 19, 20, awaiting information, 21,
It was
22.
withdrawn, my lord. It was withdrawn on 4/4/2016. It was withdrawn.
No,
only
no,
on-
see, it up to 22/7/2022 proceeding I am reading. No intimation received from the High Court.
My lord.
And put up the date for awaiting intimation on
My
LCR.
lord.
And what the trial court, how can you blame the trial court? You take a stay,
My lord.
drag it for 5 years.
My lord, it was withdrawn. It was withdrawn on 4/4/2016. So,
But it was not intimated to the court. Where have you filed the certificate copy? You took the stay and kept it with you and withdrawn the petition in the High Court and don't intimate the court.
my
And till 2022, you have not done all
lord,
that.
apart from that, my lord. Apart,
Not apart from that. That was the only consideration.
my lord.
That was the only consideration I issued notice.
Yes, my.
I was thinking of, it is, you
My
can't
lord,
blame this.
inordinate, apart from inordinate delay of disposing the matter, several decisions have been.
Forget about decision. That was that is how you have persuaded me to issue notice. I was intending to pass it, but see, this is your conduct. What
My
you
lord, all of them, sir. All of them, my lord.
go and argue
My lord,
at the stage of charge and
my lord.
learned counsel for the petitioner assails seeks indulgence of this court for quashing of the entire proceeding on the ground that although the cognizance was taken on 30th 11/2013, the trial is not proceeding for an inch even today, even after lapse of a decade. This court had issued notice on 26/2/2024 for obtaining instruction regarding the cause of delay. Letter counsel for the petition has submitted the certified copy of the proceeding of the court below, proceeding of the court below. The perusal of the proceeding indicates that on 7/1/2015, the petitioner has obtained a stay order from this court. This court. The stay order was operating up till কেবে withdraw কলো আপন কেবে কলে up till 2016 up till 2016 and eventually the proceeding before this court was withdrawn by the petitioner. However, the same was not intimated to the trial court. Therefore, the matter got adjourned up till 22/7/2022. 2022. Since the LCR was called for by this court and the same was not returned back to the trial court, the trial could not be proceeded. Therefore, the charges, even the charges could not be framed. Charges could not be framed.
I have cited some decision.
1 minute. The certified copy of the trial court proceeding is taken on record.
My lord,
I am giving you the liberty, sir. Charge. I am fixing a date for framing of charge. You go and argue whatever point you have on merits.
my lord,
Because you have challenged only the cognizance order, I am giving you that liberty. You go it. I am fixing a date before trial court for the purpose of argument on charge. You go and argue on merits. Okay, right on. Letter of counsel for the taking into consideration the aforementioned facts, taking into consideration the fact that the matter, the present case is pertaining to 2013 and cognizance was taken on 13. I am of the considered view that the petitioner should appear before the court on or before 30th of April 2024 and move appropriate application, raising all his points on merit regarding the charge, regarding the charge. Regarding the charge, the court below may consider the case on its own merit and proceed with the matter. with the observation and the liberty granted to the petitioner.
I will be punished one thing. Yes. I think section 28 of that.
Merit, I will not bear it. Merit for the purpose of framing of charge, I have given you liberty. Argue everything.
I don't know, meantime, several judgments have been made.
You tell all this to the court. I in the cognizance stage, I am not going to.
My lord, all these cases have been passed at the stage of cognizance. My lord, would
It's
it
all right,
consider, my lord,
But
hypothetically?
you have taken stay and kept it pending for 1 decade. What is this?
No, my lord,
Next.
it is.
Okay, I have given liberty. Next. Okay, 48. Our merit See, this is very unfair. You took the stay and kept it for withdraw the matter, don't intimate to the court and enjoy the proceeding. And making a grievance here saying that since last 2 decades nothing is moving. I should have dismissed it. I should have dismissed it with heavy cost. Heavy cost. But I'm giving you the liberty to go and argue. Because on merit you may have a good case. I don't know. Anyway, next. 49.
Ability to withdraw file and withdrawal.
49. Okay, withdraw.
File a memo.
Yes. 50.
May I plead with us? My lord, this is a case arising out of a civil dispute. The annexure 2, page number 16. My lord has got page number 16.
You are challenging cognizance order?
My lord.
Yes.
I'm challenging the cognizance order under annexure 8, my lord.
It is arising out of a 1cc case.
My lord.
Yes. Tell me, what is the allegation? Yes.
My lord, the annexure 2 is the first complaint case. The matter arising out of a civil dispute. Firstly, it was arising out of a boundary dispute, and second, the present case arising out of a falling of a coconut tree, my lord. Arising out of that dispute, a case under section 341, 294, 323, 354B, and 34 IPC has been lost.
506.
506. Yeah.
Yes.
My lord, the annexure 1 is the present affair. The annexure 2 was the previous complaint case that has been filed by the mother of the informant, the present informant, that has been dropped. That had been dropped for non-prosecution, and the order of that 1cc case is at page number 20, my lord.
Which page you want me to see?
Both 16 and 20.
You are telling a page and going somewhere else.
No, my lord.
You tell me finally which page I want to see.
The page number 20, my lord.
20. 20.
Yes, ma'am.
Okay. This is regarding what? The first case.
The first case.
Okay.
Which has been filed by the mother of the petition. Informant. Yes, my lord.
Filing. Who are you in this?
I'm one of the accused, my lord.
What is your name?
Yagyandatta.
Huh?
Yagyandatta Sahu.
You are not accused in this case.
Not in the first case.
First case you are not.
I am accused in the second case. But my father and other family members were the accused.
What is your father's name?
My father's name is my lord, Dayanidhi Sahu.
Then accused number 1.
Yes, my lord.
First case.
Yes, my lord.
Okay. What happened?
So the page number 20, why I'm likely to draw, my lord, on page number 20, because the first 1cc case has been dropped by the law and court below, as it has not been prosecuted.
Case was dismissed.
Case was dismissed for default, my lord.
Okay. This was on 14.
Yes.
5/12/2014.
5/12/2014.
Okay. What happened there?
Then another affair has been lost. That is under annexure 1, my lord.
Right. What is the allegation here?
10. I'm coming to the allegation. The exact allegation is at page number 12, my lord. My lord, may kindly have a glance.
Read it.
The relevant portion is 4th line. Ambhara eko nadiya gacha. My lord has got it. The 4th line of the affair.
Right.
ଆମ୍ଭର ଏକ ନଡ଼ିଆ ଗଛ ଆମ୍ଭର ପଡୋଶୀ ଦୟାନିଧି ସାହୁଙ୍କ ଫାଙ୍କା ବାରିରେ ପଡିବାରୁ ଦୟାନିଧି ଓ ତାଙ୍କର 3 ପୁଅ ଯଜ୍ଞ ସାହୁ ବିଭୁ ସାହୁ ଜ୍ଞାନ ସାହୁ ବିଭୁ ସାହୁ ଆଉ ଯଜ୍ଞ ସାହୁ 2 ଝିଅ ଯଥା କବିତା ସାହୁ ସବିତା ସାହୁ ମା ଇନ୍ଦୁ ସାହୁ ମତେ ବିଭିନ୍ନ ଖରାପ ଭାଷାରେ ଗାଳି ଗୁଲଜ କଲେ। That is one of the relevant
Right,
against me.
read it, read
Yes.
it.
ମୁଁ ଏବଂ ମୋର ବୁଢୀ ବୋଉ ବିଳାସିନୀ ନାୟକ 75 ବର୍ଷ ସବୁ ସହି ରହିଲୁ। ଆଜି ସୋମବାର 6/5/19 ସନ୍ଧ୍ୟା 5ଟା ସମୟରେ ବିନା କାରଣରେ ଦୟା ସାହୁ ଏକ ଶାବଳ ଧରି ମୋ ପେଟର ଭୁସି ଦେବାକୁ ଚେଷ୍ଟା କରିବାରୁ ମୁଁ ତାଙ୍କ
This
ହାତ
is all relatable to an incident of 2019.
My lord.
July 2019.
My lord.
You attack a
I have
coconut
not.
tree fell down.
Yes.
You attack. This is the 19. And the earlier case was relating to 2014.
Yes, my
After 5 years, this has happened. How do you correlate it?
That is what I am coming, my lord. The allegation, the first allegation against me is that I am Jagya Sahu, my lord.
The same Nodia Gosata 2014 ରେ ପଡିଥିଲା.
That is regarding the
2019 ରେ ପଡିଲା.
regarding the civil dispute, my lord. Boundary dispute was
the
there.
Allegation in this FIR, it is a cognizance thing. And now
It has been charge sheeted, my lord.
charge sheeted.
No, admittedly, it has been charge sheeted and
Come
cognizance
to the
has already been taken, my lord.
Come to the charge sheet.
Yes. My lord, just 2 lines of the FIR, then I will come
Yes.
to the charge.
Read it, read it.
My lord, in the last, in the page number 13, my lord,
Yes.
Yagya Sahu, third line, Yagya Sahu moste bidha goitha mari chuttiku bhidi marila. So, 2 allegations against the present petitioner, my lord. The first is Ambhara ek padibaru Dayanidhi Sahu, Yagya Sahu, ଦୁଇ ଝିଅ ମତେ ବିଭିନ୍ନ ଖରାପ ଭାଷାରେ ଗାଳିଗୁଲଜ କଲେ. That means most 294 will attract against me. And the second is ମତେ ବିଦା ଗୋଇଠା ମାରି ଭିଡି ରହିଲେ. Now let's say kindly have a glance to the charge sheet.
Right.
Annexure 6, page number 24.
Right. Yes.
My lord, the charge sheet is charge sheeted under 341. My lord has got it 4I.
Yes.
341, 294, 323, 354B, 50634. And the cognizance order is under annexure 8.
All these offenses.
Page number 39. My lord, my humble prayer is how the 354B will be attracted against me.
So then what is the procedure?
My lord, the
cognizance is taken.
Cognizance has
And
already
you
been
say
taken.
particular offense is not made out.
My lord,
What is the procedure?
The procedure I can
At the
argue.
stage of charge, you have to argue. This is made out. This is not made out.
Yes.
That is already, my lord.
Then
But
why have you come here?
the main crux is arising out of a civil dispute, my
Everything is
lord.
all right. I accept everything. But what is the stage?
Admittedly, I have
You
challenged
say
the
that
cognizance order.
out of the 5-6 offenses, only two is made out, others are not made out. That at the stage of trial, you have to segregate and argue. See, on the basis of this, I have to read everything. What are the evidences? What 161 statement and everything. And cognizance says I can't.
Even in 161 statement of the.
I am accepting it to be correct. Even then, I have to go through everything to segregate the charges.
I bow down to a lordship, but even in 161 statement and the affair, it is also contradictory to each other. So when
you argue those
the present petitioner is a civil servant aspirant. He has already appeared in the civil service. So only because a civil dispute, he has been dragged for last from 2019, my lord.
What are the offenses not made out according to you?
354B is not made out.
354B.
Yes, it is not.
Outraging modesty.
In order to disrobe. 354.
I don't know what you have done.
No, my lord, the affair contention has totally silent about the same.
Do I need to go into all these things?
My lord, at least affair contention clearly
you are on
speaks
bail?
otherwise.
Are you on bail?
Yes, I am.
You are on bail. Argue it before the
at least
and the law what to do.
At least notice may be given and short date may be fixed.
Why are you going to settle? I'll record it.
It may be settled. That is why
you will settle it. I'll record it and call them and get it settled. Because these are small offenses.
But if lordship will admit
I will
and
not
notice,
insist them to settle.
No, I am not.
You tell. You are the accused. You won't tell. They are your neighbor. You can persuade them.
At least short date may be fixed. Notice may be issued. If matter will be settled, or else I will withdraw.
No. If then I will not issue notice.
That
for there should be a cause to issue notice. Otherwise, I will give you liberty and go and argue everything. You have a fantastic case. These charges will be dropped. If these charges will be dropped, few charges will be there. There are allegations against you.
If
ଲେଖିଛନ୍ତି compromise କଥା ଆପଣ ବସିକି ନେଇ ଆସୁନ।
let's say may fix
And I'll
the
send
date,
it
I'll
to-
take instruction
I'll
regarding.
send it to mediation once you come, once they come.
That is what I'm saying. If a notice will be served, they after they are coming, matter may be settled in the mediation.
But I have to record that you are settling the.
It likely to be settled.
Right. The petitioner is challenging the order dated.
My lord,
Order dated
6/12/2019.
2019. What is the stage? Charge has been framed.
No, my lord, charge has not been framed.
Are you sure?
Yes.
Because 2019.
Yes, my lord, I have taken the
Charge has not been framed. Whereby cognizance of offense under section so and so has been taken against the petitioner. The land account for the petitioner submits that insofar as the present petitioner is concerned, the out of present petitioner is concerned, there are only two allegations. What are the two allegations?
One is Gali Gulaj Kala, filthy language.
Allegation, namely, he has used filthy language and scolded the informant and has given fist blows and
Bidha.
and has given fist blow to the informant. On the basis of the aforementioned allegation, even if it is accepted to be true at its face value, no offense under section. Which section is not made out?
354B.
354B and
506.
threaten করছো মার দিই বলি কি লেখা আছে না রে
341 भी हो नहीं my doubt. But it's available.
354B 506 and 294 506 is not made out. In fact, he ought to have argued this point on merits at the stage of framing of charge. However, the petitioner submits that there is a likelihood that the matter would be settled between the parties. Therefore, I am persuaded to issue notice to the opposite party, returnable within 1 week. Next week, may record. Bring him and go and tell that please settle, so that at least you'll come out. Even if you succeed, 2 offenses goes, the other 2 offenses will you have to pay the trial. Better that you go and tell.
Yes, ma'am.
I'm issuing notice. Okay.
2 weeks. ଗୋଟେ week ରେ କାଳେ ପହଞ୍ଚି ପାରିବ notice.
1 week only. You ଯେତେବେଳେ କରିବ ଯଦି ହବ ହବାର ଅଛି ହବ ନହେଲେ then you will do whatever. ठीक है. 1 week entry ଦେଇଦେବ next week. 18 ଦବ ନା 18 ଦିଅ 12th or 15 ଦିଅ 15
IA has been filed.
No IA. Nothing will happen. Next.
At least
that IA is the only dangerous thing. Once IA is allowed, then you are
no,
you will not no question of stay.
Till 50.
I am just giving you indulgence because you only one word has persuaded that he is aspirant of civil service. Young boy. So
he has already my lord, he has already appeared in the OS main exam.
Nothing will happen. Bring. Shall I put it on 12th?
Anyway, my lord.
You bring them. I will persuade them to settle it and finish it up, so that we'll get out of this mess.
Diplomas.
And if you have any coconut tree, cut it now.
Diplomas.
For every coconut tree, there is one case. Yes, next. Okay. Yes. 51.
My lord, I may permitted to place the matter on behalf of Mr. S.S. Rai, my lord.
Sorry?
I may permitted to matter on behalf of Mr. S.S.
Yes.
My lord, the matter has been settled between the parties. The case and counter case. In counter case, other parties have before.
What are the offences?
Offenses, my lord, 341, 294,
307.
My lord. Case and simple in nature. Case, counter case. Counter case also pending.
Where is that?
That is CRLMC 1935 of 2022.
Bring them tomorrow.
Next week, so that 2 other counsel are there.
50.
My lord.
50. Connected matter. What is
CRLMC number 1935
across cases, yeah?
of 2022.
15.
My lord.
15 ki 16. 15 draws. Bring them together. We'll finish it up. Okay.
Please, my lord, in this case, I am the opposite party.
I have filed a IA, my lord, for modification,
You are the opposite party.
my lord.
What
So,
modification you want?
my lord, modification I want, my lord.
Modification of what?
My lord,
Order dated
my lord, order dated.
1/2/2024.
My lord, my lord.
What modification you want?
If your lordships kindly see the ordering portion, paragraph 5, my lord.
Paragraph 5.
5, my lord.
In the interim, the parties have settled the dispute and the opposite party number 2 has agreed to receive 20 lakhs as full and final settlement towards the dispute, out of which the petitioner has already paid 6 lakhs and he undertakes to pay. Yes.
My lord, my humble submission before your lordships, my lord. Admittedly, the settlement is going on, my lord. The amount, the NI Act under section 138 NI Act was filed by me, the complainant. The petitioner is an accused.
66 lakhs is check amount.
My
You
lord,
have settled for 20 lakhs.
my lord,
That's
no,
what I have recorded.
no, my lord, that is not 20,000. Sorry, my lord, 20 lakhs, my lord.
You only told me how will I get this figure then?
My lord,
Where from I get the figure?
my lord, that they have not mentioned, my lord. The petitioner.
I don't know. You have told. How would I know?
No, my lord, my humble submission before your lordships that I have.
Where is the petitioner?
May appearing
Where from I got that 20
in
lakhs?
last occasion, Lordship, in the first date of admission of the matter.
And it is in your presence I am passing this.
Yes,
order.
Your Lordship. My responsible submission, Lordship, out total amount has been settled in 20 lakhs, Your Lordship.
You
Out
have
of
agreed.
20 lakhs, I have already paid 6 lakhs. That not been disputed by my learned friend, Your Lordship. And now your Lordship is granted till 30th April is the last date to payment the balance amount of 16 lakhs, 14 lakhs out of 20 lakhs. That accordingly I have now I am in bail. And last day 34 is the last date to repay the balance amount. My learned friend is filed in such a miscase. I have copy not been sought to me. What sought for modification? I am not aware of that miscase, Your Lordship.
Because my humble submission before
20 lakhs modified to?
My lord, the amount has not been fixed, my lord, between the parties, my lord.
Where from I got this?
My
Because I
lord,
have
they
recorded in your presence.
My lord, my lord, I could not follow that order, my lord. I
See,
could not follow, my lord.
I'm-
They have, the petitioner has not mentioned, my lord. The petitioner
मैं
has
ମୁଁ
not
ସେଇଟା ଟିକେ କ୍ଲାରିଫାଏ କରିଦଉଛି ଯେ perhaps my learned friend is an apprehension that ଯେ 20 lakhs ହେଲେ ସେ କାଳେ ମାନେ ସେଟଲମେଣ୍ଟ ଆମାଉଣ୍ଟ ହେଲେ ଫିକ୍ସ ହେଇଯାଉଛି ଗୋଟେ କୋର୍ଟରୁ ମାନେ ଅନରେବଲ କୋର୍ଟରେ ଗ୍ରାଣ୍ଟେଡ ଫିକ୍ସ ତେଣୁ ମାଇଟ୍ ଅଫ୍ ସେଟଲମେଣ୍ଟ ହବନି ସେଥିପାଇଁ ଆପ୍ରେହେଣ୍ଡ କରିବେ ସେ ମିସକେସ୍ ଫାଇଲ କରୁଛନ୍ତି କପି ତ ମୋତେ ଦେଇନାହାନ୍ତି ମୋତେ କପିଟା ଦିଅନ୍ତୁ on the first occasion by presence of my learned friend is the order has been passed and my responsible submission is total amount has been settled 20 lakhs. That is my responsible submission accept to that effect. And
It is not, he has not agreed to that.
yes, agreed. But on paper, my learned friend is not tried to mention in that the total out of total amount 60 lakhs, that amount has been settled in 20 lakhs. My learned
What
friend is
modification I will do? Tell me.
My lord, 20 lakhs may be deleted, my lord. Only the matter is going to be settled.
Going to
Right
let's say
Right on. By the order dated 1/2/2024. In order dated 1/2/2024 passed by this court. Court in para 5. It is found mentioned that the parties have settled their dispute for an amount of rupees 20 lakhs, out of which 6 lakhs has already been paid. Let the counsel for the party submits that the agreed amount of 20 lakhs found mentioned in the order may be modified to the extent that the parties have only settled the dispute and the amount has not yet been the figure is not yet been figure of 20,000 20 lakhs found mentioned may be removed. Accordingly, the modification application is allowed. With the modification application is allowed, and the para 5 of the order dated 1/2/2025 may be read as under. In the interagnum, in the interagnum, the parties have settled their dispute, and the opposite parties has agreed to receive has agreed to settle the dispute and settle the dispute. Settle the dispute, full stop. Towards the initial settlement, the petitioner has already paid 6 lakh rupees, which has already been received by the petitioner number 2.
Opposite.
Petitioner number 2. And the remaining settle amount shall be paid on or before 30th April 2020.
Your Lordship, kindly that period may kindly be extended, Your Lordship, because now the amount has been settled in 20 lakhs. That too, I have been
The remaining
till 30th June,
amount
Your
of
Lordship.
settlement, remaining settled amount shall be paid on or before 15th of May.
31st of May, Your Lordship.
31st,
Your
because
Lordship.
now it is increased. 31st.
Right, Lordship.
I will adjourn all revision matter. I'll just check it up. What is the position? Then I will.
Item 7. Lordship, kindly taken up next week because of Mr. Mahanti was
7 adjourned.
7 minutes.
Yes.
54.
It will be taken out after lunch. You are the accused.
And that.
You're right.
My lord, what has happened, my lord, check was drawn in the bank of HDFC Bank, Soidnagar branch. And the check was presented by the complainant before the Bank of India, Tripura branch. So the check, the 138 complaint petition can be filed either at where the check was drawn or the check was presented in view of the amendment in section 142 of the NI Act. But the no cause of action was arose within the jurisdiction of the SDJM and the court. My lord, your lordship may kindly see annexure 5.
You moved application before that court.
Yes, my lord. I moved application. It was rejected. It should have been filed before the Gramonayala, Ghasipura. My lord, the police station wise magistrate assignment, your lordship may kindly see at annexure 5, page 28. My lord, Anandapur, SDJM Anandapur, having jurisdiction over Andapur police station. So far as the serial number 6, your lordship may kindly see of the said notification. Gramonayala, Ghasipura, Ghasipura police station and Ramchur.
Read the impugn order.
Yes, my lord. My lord. Advocate for the complainant, 32, page 32 is the.
I'm on that one.
My lord. The advocate for the complainant is present. Advocate for the accused is present. File Sajira record is put up today for hearing on the application filed by the learned counsel. 32. 32. 32.
Okay. Ready.
My lord. At this stage, the learned counsel for the complainant files a copy of the notification number 9527 dated 26/8/2010 issued by the Government of Odisha Law Department for perusal of the court. Copy of the same served on the learned counsel for the accused person. Similarly, learned counsel for the accused files a copy of the Gramonayala Act specifying the jurisdiction of the Gramonayala with a copy of the counsel for the complainant at both sides. The learned counsel for the accused argued that since the check was deposited by the complainant in this case at Bank of India Ghasipura branch and as such the same is not situated at Andapur, this court has no jurisdiction to take cognizance of the offence and try this case. On the other hand, the learned counsel for the complainant argued that the petition is not maintainable as Bank of India Ghasipura branch is situated under Andapur municipality and the SDJM Andapur has territorial jurisdiction. In support thereof, they filed the relevant notification of law department, which provides that the Gramonayalas have territorial jurisdiction over local limit coextensive with the local limits of jurisdiction of Ghasipura Panchayat Samiti. As such, since the Andapur municipality does not come within the jurisdiction of Ghasipura Panchayat Samiti, this court has ample jurisdiction to try this case.
What do you want?
My lord.
It has jurisdiction because it
My lord,
comes under the
no,
Anandapur.
my lord.
The jurisdiction under section 7 of the CRPC has been vested with the magistrate on the basis of the police station.
But he says that is Anandpur, the
No,
entire
that-
Anandpur comes under. See, it is
No,
not,
my lord.
see,
And
it
he
is not on the
says-
basis of police station.
No, he
It is
says-
on the basis of the check where it is given on.
Yes, my
Or
lord.
it is check presented. It is, it's coming under the Anandpur.
No, my
City
lord. It is not coming on the
Bank of
Anandpur.
India, Anandpur.
No, Bank of India, Ghasipura.
That is coming under the Anandpur
No, my
region.
lord. It is his submission. But Anandpur, Bank of India, Ghasipura comes within the Ghasipura Panchayat Samiti. The notification, government notification, law department notification, your lordship may kindly see. It is coming within the Panchayat Samiti, local limits of the Panchayat.
Next paragraph read.
Yes, my lord. Peruse the complaint petition and documents available in the record. According to section 142(2) NI Act, the offence under section 138 NI Act shall be inquired into and tried only by a court within whose local jurisdiction if the check is delivered for collection through an account. The branch of bank where the payee or holder in due course, as the case may be, maintains the account is situated. It is undisputed that in this case, the check was deposited by the complainant at Bank of India Ghasipura branch. The court of SDJM Andhapur was established much prior to the Gram Nayada, which was established in the year in 2010 by virtue of notification number 9527 dated 26/10/2010 issued by the government of Odisha Law Department.
I don't find any infirmity in this.
No, my lord, your lordship may kindly say there is completely miscarriage of justice, my lord. Your
What
lordship may
miscarriage of
kindly say
justice? What is the check amount?
My lord, check amount is
Come to the point. What is the check amount?
My lord,
You have
my-
given and you are now taking these small pleas and avoiding it.
no, my lord, these cases.
What is
are
the check
being-
amount you
My
tell?
lord, check amount is 27
Sir,
lakh.
27 lakhs.
27 lakh.
27 lakh.
Now you have taken 27 lakh check you have given now.
No, my lord, that is to
this
be
plea
decided
that-
whether I have taken.
2019. Have you paid 143, complied 143?
No,
If
my
you 20%, I'll interfere. Otherwise, not interfere.
Yes, my lord, I have deposited 25. before
Subject
this
to
court, my
petitioner
lord.
depositing 20% of the check amount.
My lord, trial court has directed for 1,50,000. I have deposited.
I'm saying 20% of check amount,
But-
whatever you
my
have
lord,
paid.
that is more than the
No,
court
that is
directed.
that is the requirement of law.
My
See,
lord-
try to understand.
No, my lord, that law has
2019,
been changed, amended, my lord. That law has been changed by the order of the Honorable Supreme
you
Court.
seek
It
in-
is not mandatory. Earlier it was mandatory.
but I am making it mandatory under 482.
My lord,
Because
that your lordship
see,
can
try
make.
to understand the plight of a person. 27
My
lakh
lord,
rupees.
he has not paid. He was working on as the
Whatever,
contractor. He has
it's-
taken the
within
check.
6
He
months-
did not,
Within 6
discharge-
months, the complaint has to be tried. This is
Yes,
the law.
my lord.
This is the law.
My lord.
2019 is file. You move one application or the another. This clear. How does it make difference to which court? It doesn't have.
My lord, the court having no
See,
jurisdiction cannot
It's all
try, my
right.
lord.
You will get benefited. Why do you worry?
So that is what I am.
Not wait.
That is
Go and
what
face
I-
the trial. Go and face the trial. If it incompetent jurisdiction, even if you are convicted, you will be acquitted. So be happy and enjoy.
The court having jurisdiction. Your
It
lordship
has
may-
jurisdiction,
Your
sir.
lordship may direct deposit 10%.
It has jurisdiction according to me.
My lord,
The
if your
order,
lordship will
I
go
did
through-
not interfere.
My lord, your lordship will, if you go through the notification of the.
Do you want me to take a view? Then I'll take a view.
Your lordship, my lord.
I'll take a view. Judgment will job. Give it, huh? Judgment.
My lord, may kindly say it. Only I may be permitted to place your lordship's attention. to
Only
the
I have to read the
notification.
notification and complaint copy. Everything you have filed, fortunately. I'll read
Yes,
it.
I have filed. My lord, that is why I'm trying to take your lordship to, my lord, annexure 4.
Oh, okay.
What is the notification, my lord?
So-
That jurisdiction is coextensive with the jurisdiction of, my lord, the Ramanayana established up in the year 2010, having the
Read
jurisdiction.
20%. The grammar so
My lord.
established shall have the territorial jurisdiction over the local limit
Ghasipura Panchayat
coextensive with the limit of jurisdiction of Ghasipura Panchayat Samiti.
Yes, my lord.
Only
No,
it
this-
says Panchayat Samiti.
My lord, this
And headquarter
and the
located
headquarter.
in Ghasipur, it shall exercise both civil and criminal jurisdiction in the manner and so extent provided
So,
under.
my lord, the Ghasipura Panchayat Samiti headquarter is coming within the limits of the Bank of India Ghasipura branch.
No problem.
So therefore, my lord, your lordship may kindly see the assignment of the magistrates, my lord.
Next page, 28.
My lord. Clearly stated, the SDGM only Andapur police station, and so far as serial number 6 is concerned, my lord, it is Ghasipura police station and Ramchandrapur police station. Both are coming within the, my lord, Ghasipura Panchayat Committee, my lord. This Ghasipura police station is coming within the local limits and headquarters of my lord. So therefore, my lord, all the cases have been transferred.
I'll take that into consideration.
My lord, all the cases have been transferred. My lord, this case can be transferred, my lord.
Show me one case.
Yes, I'll produce, my lord. I'll produce, my lord, the certified copy of the cases which has been transferred from Andapur, SDGM Andapur to Nayada.
See, if it is a case registered in a police station, it can be. It is a complaint case around 138. Why are you laboring hard for that?
My lord,
see, you are showing me
can
two police
understand.
stations. All the police station cases registered in the police station that will be tried as per that notification. But it is a case under 138. It is
Complaint, my lord.
The bank is in Anandapur.
No, my lord, the bank, your lordship, my lord, it is in Ghasipura, my lord.
But it is under the jurisdiction of Anandapur.
No, my lord.
That is what the order
No, it is within the limit of the Ghasipura Panchayat Samiti as per the government, my lord.
No will not make no.
My lord, may kindly say the notification.
You show me one 138 case which has been transferred.
Yes, I will produce the certified copy. All the cases
Tomorrow?
from SDGM Andapur has been transferred by the learned district judge.
Tomorrow or day after?
No, I'll take 1 week time, my lord, to obtain the certified
Next
copy.
week. Next week, get it.
Yes.
If you have that, then
Yes, my lord.
on
Those cases have been transferred.
the basis of parity. And why don't you move an application before the DC judge? I'll give that liberty.
I want to take advantage of it, my lord.
Then you go and move. I'll make it an observation and dispose it out. Right out.
Yes,
right
my
out.
lord.
If it-
Your lordship
no,
may-
you know, and if it is there, then he will
yes,
do it.
madam.
Why to produce here?
Yes,
Go ahead. The petitioner has challenged the order dated 11/12/2023 passed by SDJM Anandpur in ICC case number 112 of 2019. 2019, wherein the application of the petitioner regarding the
Want of jurisdiction.
Want of jurisdiction of the said court has been turned down. The consider the petitioner submits that after the notification, government notification dated 26/8/2010, Annexure 4, the territorial jurisdiction to try the ICC case falls under Gram
Nyaya
Ghasipura. Ghasipura. However, the court below has taken a different view. He seeks to withdraw this present petition to move appropriate application before the decision judge for transfer of the present case to the appropriate court.
To the court of the
appropriate court having jurisdiction to try the present try the one CC case as mentioned. The petition is disposed of with liberty to the petitioner to move appropriate application before the letter decision judge. If such application is moved, the same shall be disposed of in accordance with the law. Right. Yes. Disposed of. Yes.
26.
May I please, Your Lordship? Anticipatory bail was granted, Your Lordship, but direction was issued to the arresting officer to release on bail, but item 26. But the IO has not arrested the petitioner and submitted charge sheet. Thereafter also not arresting the petitioner and humiliating in public, Your Lordship. For that, Your Lordship, the petitioner before this honorable court to pass the imbue and direct me to surrender and go on
No,
bail.
you are challenging the cognizance order.
Yes, Your Lordship.
Because the IO is misbehaving with you.
No,
Therefore, cognizance order is required.
Cognizance and irregular. I only prayer, Your Lordship, may By the similar order lordship annexure 4, so for the co-accused person, this honorable court directed to surrender and go on bail lordship. He was not granted anticipatory, but I have been granted anticipatory bail. That is the differential lordship.
Where is the bail?
Bail order annexure 3, page 89.
89.
My lords. Ordering person at 91.
90?
91 ordering person, page 3 of the order,
Mhm.
page 91, considering the submission made by the counsel for the respective parties.
91. 91. Huh?
My lords.
You are Kanucharan Manti.
No, my lords. This is Sutam Charan, my
What
A
is
bail.
your name?
Kanucharan 92 is the co-accused lordship.
92 co-accused.
This order lordship.
1 minute. 90. Your bail order is?
Started from 89, ordering person at 91.
91. What is the order?
10,202.
Sudama Beura.
Fine.
What was the order? Considering submission made in the body document.
In the event of arrest.
In the event of arrest, you shall be released on bail and all. And thereafter what happened?
ଯେହେତୁ
He has not.
ଚାର୍ଜସିଟ୍ ସବମିଟ୍ ହେଇଯାଇଛି ପୋଲିସ କହୁଛି ମୋ ପାଖରେ ଆଉ କିଛି କେସ୍ ନାହିଁ ମୁଁ ଆରେଷ୍ଟ କରିବିନି କି ବେଲ୍ ଦେବିନି କିନ୍ତୁ ପବ୍ଲିକଲି ଦୋ ପିଟିସନ ଇଜ ଏ ପଲିଟିକାଲ ପର୍ସନ ଯୋଉଠି ମିଟିଂ ମାଟିଂ ତାକୁ ହ୍ୟୁମିଲେଟ୍ କରୁଛନ୍ତି
Then what do you want now?
ଏବେ ମୁଁ ସରେଣ୍ଡର କରିକି କୋର୍ଟରେ ଆମେ ବେଲ୍ ଯିବା ପାଇଁ ଚାହୁଁଛୁ ଦ୍ୟାଟ୍ ଅର୍ଡର ହେଲା ଆନେକ୍ସର 4 ଅର୍ଡର
You are already on the bail. What?
Your lordship is holding which order, ABLPL number 2599 of 2022?
ନାଇଁ ନାଇଁ
9474.
এটা তো ନାଇଁ ମୁଁ ଗୋଟେ ଧରିଛି ଅର୍ଡର ସେଟା ରିଜେକ୍ଟ ହେଇଛି।
ସେଟା
नहीं,
ଏଇଟା
9474 रे ସୁଦାମା ଚରଣ ବେଉରା ଇ ସୁଦାମା ଚରଣ ବୋନ ନା ୟୁ
ହଁ।
ସୁଦାମା ଚରଣ
ମାଇନର
ସେ କୋଉଟା ଧରିଛନ୍ତି ଇଏ ଲର୍ଡସିପ କାଇଣ୍ଡଲି ସି ମାଇ ଅର୍ଡର
ନାଇଁ ବ୍ରିଫଟା ଦେଖୁନା
ନାଇଁ ନାଇଁ ମୁଁ ଏଇଟା ଧରିଛି ମୁଁ ଗୋଟେ ବାହାର କରିଛି ଏଇଟା ଦେଖ
ସେଇଟା ଏଥିରେ ଆଜ୍ଞା 100 ଜଣ more than 100 accused persons are there
ଇଏ ଲର୍ଡସିପ କାଇଣ୍ଡଲି ସି ଦିସ୍ ଅର୍ଡର
କୋଉଟା
Yes.
ଏ ଅର୍ଡରଟା ଦେଖନ୍ତୁ ଏ ଅର୍ଡରଟା ଦେଖନ୍ତୁ ପାରାଟା ଦେଖନ୍ତୁ
ये ସୁଦାମା ଚରଣ ଇଏ ବି
Yes, ସୁଦାମ ଚରଣ ଦେଖନ୍ତୁ ଆଜ୍ଞା ସେଟା ପାରା 1 ପାରା 2 ତ ଲେଖା ହେଇଛି ଯେ ପିଟିସନ ନମ୍ବର 1 2 3 or 12 something else prayer for bail is rejected so for other petitioner are directed to be released on bail on surrendering you also may kindly see that
stands rejected.
yes
This is an order dated. This is an order dated.
ମୁଁ ଜାଣି ଏଇଟା ଗୋଟେ ଅର୍ଡର ବାହାରିଲା ତ
6/4/2022. 2022. 15/11/22. तापर आउथरे सेकंड एप्लीकेशन यू मूव
ହଁ ଆଉ ଗୋଟେ ଫାଇଲ କରିଥିଲେ ସେଟା ହେଲା ABLPL 9474 of 2022 if that is if I am
brief 89 page
ସେଟା ଆଉ ଗୋଟେ ଫାଇଲ ହେଇଥିଲା ତ ଏଇ ସବୁ
सेकंड टा फाइल हिची सेकंड रे सेमन पाई
again
you have filed alone. He has
Mine.
filed alone. This is
Mine.
single petition.
minors
ଏଇ କପିଟା ଆଧାରେ କାଇଁ ସେ ଯୋଉଟା ଏଇଟା
ଏଟା 89 page 89 answer
89
again
Right now, the petitioner is an accused in FIR number so and so so and so. Petitioner along with 32 others, they applied for anticipatory bail by moving ABPL number 2599 of 2022. The coordinate bench by the order dated 6/4/2022 rejected the anticipatory bail application of the petitioner along with a few of the accused, whereas while granting anticipatory bail to many other accused person. Subsequently, the petitioner has filed another application being ABPL number 9474 of 2022. While order dated 15/11/2022, the coordinate bench extended the relief of pre-arrest bail. Pre-arrest bail. Pre-arrest bail. Next paragraph. The learned counsel of the petition submits that after the said order, the police is neither issued notice to him nor summoned him for extending cooperation to the investigation. However, filed the charge sheet. Pursuant to the A charge sheet NBW has been issued on
तो 25/5/2022
pursuant to the said, since the petitioner had no knowledge, he could not appear in the court. Therefore,
No, on the prayer of IO, NBW was
and what is it? No, the petitioner no knowledge and on the request of the IO, NBW has issued against the petitioner on
25/5/2022
the petitioner, learned counsel of the petitioner on instruction submits that he would be appearing before this court on and before 30th of April 2024 and avail the remedy under law, taking into consideration the statement made at bar, the operation of NBW issued against the petitioner, provide order dated, NBW orderly so, shall be kept in events till 30th April, so as to enable the petitioner to appear before the court and seek remedy under disposal.
Annex 4 direction was.
Yes. Learned counsel of the petitioner on instruction submits that his client would be depositing 50,000 rupees, being the 20%.
My lord, it has to be 70,000. The 20% of 3,50,000.
The modification application, the counsel of petitioner submits that this court by the order dated 19/2/2024 directed the petitioner to deposit 20% of the check amount, which comes to 70,000 rupees.
Yes, sir.
70,000 rupees. However, in the order dated 19/2/2024, rupees 50,000 was directed to be deposited, being the directed deposit. Accordingly, he needs modification of the order. Taking into consideration the arguments made in the application, the same is allowed, and in place of 50,000 rupees to be deposited by the petitioner, the petitioner needs to deposit 70,000 rupees. With this modification, the application, this modification, the said modification may be carried out in the order dated 19/2/2020.
Time may be extended. 15 days, within 15 days it was ordered.
He further submits that the time granted to the petitioner to deposit the said amount may be extended up till
15 more
15
days.
More 15 days.
15 time was granted may be extended up till 15th April. 15th April, 2020.
Public.
Court appeal.
Interim order may be
Interim order will continue. When will you bring them?
29 April.
29th April. 29th April. Yes.
56.
Yes.
Let's say my kind see order dated 13/3/24.
Yes.
I have sought modification because the case number is not there. Case and code that has to be incorporated there.
By the application could have been avoided without going into the agreement for which the building is before the lower delay of review of yes, what do you want?
See case number ta debe se case number mention in case of court ta.
Your Lordship, I'm appearing on behalf of opposite party. On the last occasion, you had instructed us to file a IA for modification. I'm appearing on behalf of Gauri Monrath. Let the matter be taken next week.
No, it is again buying time.
I have passed in a case order. I have only said that
we are filing
a long bail. It should be expedited. That's all.
Your Lordship,
2018 matter.
an opportunity of hearing may be given to us.
think this unnecessary. You have all opportunity to argue there. You are avoiding there.
Your Lordship, this is a IA we are filing today.
Unnecessary. Take the IA. I will take it ahead. I will modify the order and go and argue whatever merits you
Your
have.
Lordship, the matter may be taken up next week.
No.
Your Lordship,
This is-
my senior is.
That is what is the whole problem is. He says that section 12 application he has moved. Neither interim order is passed, nor
Yes, Your
it
Lordship.
is disposed of. Just try to understand the plight of the women.
Your
No
Lordship,
maintenance, nothing.
maintenance has been given. Interim maintenance is given.
Interim maintenance is there. That does not mean that the case will not be concluded. The section says it. Section 12.
Come on,
Section 5 says that. Fifth. That says that.
File it. I will
It
not
is
further.
statutory provision.
No further adjournment. Let us consider the opposite.
But I oppose this. Why should it be adjourned?
Six adjournment. Six adjournment. Last time also.
And your Lordship will kindly consider, if at all there is any scope, then your Lordship grant adjournment, I have no objection. But is there any scope?
Lordship, the matter may come on 5th.
There is no scope of.
Last time you appeared on 19th March 2024, you have appeared.
And my senior had opposed the
No, nothing is written in the lease.
Your Lordship
Because
pass
your
order.
Lordship-
Let it be taken into consideration.
We have-
Orders may be passed.
Your Lord-
Section 12(5) is very clear. That is a statutory provision.
let the matter come on 5th.
The young man.
कौन होगा ना young man no है क्या? But your Lordship will kindly, as your Lordship said, your Lordship may kindly see the plight of the lady.
I understand it, but see.
से गोटे कोन हेइतिला से गोटे सिमिलर प्रोसीडिंग ता पेंडिंग थिला किछि प्रोसीडिंग नथला बेले हमर व्यू थिला जे किछि प्रोसीडिंग पेंडिंग नाही सो लेट इट बी concluded within a stipulated period. But when the opposite side appeared and filed a modification to that extent that the similar application is pending, and that was in view of that order, I don't know
No
exact
similar
number. I
application
don't know.
pending. No
But
similar
I
application
remember, my lord, I remember that opposite party for whom the my brother is younger brother is appearing. He has submitted. He has explained the number CRLMC or something else. I don't know.
Yes,
Your Lordship.
I should prepare and come. Why are you taking court proceedings so easily? And if you have a case, then I'll give indulgence.
Only there is a case your Lordship may have done. Yes, that is understandable.
Keep it on 5th. Let us.
Obliged.
Preemptory order. No further adjournment will be given. Yes.
It is a statutory provision.
My pleasure, lords. Yes, lordship kindly see the last order, my lord. Since it is a, my lord, case of 363 boy and girl appear before lordship last occasion, and lordship appearance was dispensed with and notice was issued to her father, my lord.
Notice be issued to opposite
Her
party.
father, my lord, who is informant. Because it is the intercaste marriage, father not accepting, my lord. And now the notice has been gone, father is your lordship kindly see the noting. Due to absent, the notice has not been delivered, that is the noting is here. So absent is not a reason for the sufficient of notice.
So what do you want?
Lordship may consider, my lord.
The presumption is that
The case of
it is solved.
363, boy and girl married and living happy conjugal life. Last order, your lordship kindly see.
Mr. Maharaj.
Last time the both the parties are
Take it up. What to do?
वो जो बाहर थे बापा को नोटिस है था बापा नोटिस रखो absent है झूले.
What had happened is, see, the girl was kidnapped and they are married.
Yes, sir.
Now happily married. And but the father is the informant. We issued notice to the father. Father is not receiving now. What to do?
A lordship notice sufficient.
Yes, address is absent due to not delivered. Absent.
As your lordship observing that, your lordship may dispose of.
Yes.
Why should the matter will be kept?
Unnecessary.
Unnecessary.
Only minor
That was
offense.
taken up.
Yes, yes.
63.
The matter was
With that
taken up-
objection, your lordship may dispose.
taken up on 13/3/2020. And following order was full order.
Egoism saruni aguno.
Pursuant to the aforementioned order, notices were issued to the opposite party number 2, who is the informant. The informant in the present case. Okay. Present case. What is the SR report indicates that although the notice was issued to the opposite party number 2, but the same could not be delivered as the addressee was absent. in view of the judgment of the Supreme Court reported in
2007 volume 6.
I'll give you that judgment.
The judgment is
Since the notice was issued in the right address and the addressee was absent, the same shall be treated as sufficient service. Sufficient service. Sufficient. Now come to the main matter. The petitioner and opposite party number 3 had were present in the court and
on the last date of hearing, they were present. Your lordship dispense with the present.
yes. Present in the court on the last date of hearing and made a conjoint statement that they have already married and settled in their life. Therefore, the opposite party number 3 the opposite party number 3 made a specific statement in the court that she doesn't want to proceed against the petitioner who is presently her husband. Mr. Maharaja, APS for the state, submits that since the parties have settled the dispute and they have married so as to save the marital life of the petitioner and opposite party number 3, indulgence of this court may be this court may give indulgence.
Yes.
May give indulgence.
Yes.
Since there is no legal impediment in passing the FIR in view of the development unfolds in the present case. In I am of the considered view that the petition deserves merit. Accordingly, it is allowed. Allowed. The FIR number so and so, and consequential proceeding arising therefrom, was the petitioner was.
Yes.
May I please, your lordship? My lord, the petitioner unfortunately filed the DCR lens instead of criminal revision, my lord. So filed this, so he has filed the IA for convert the case from DCR elements to criminal revision, my lord.
It will be converted, it will go to some other court. It has to go to some other court.
Yes, yes.
This is against the charge order, huh?
Yeah, he is saying that he has filed a IA for conversion.
This is you have challenged the charge order.
No. At 457.
Criminal case, 457.
Revision you want to file.
Yes, sir.
Criminal revision.
Criminal revision will go to decisions.
Yes, we lost it. They will file the appropriate
You
application.
have to file there only. Even if how can I?
My lord,
revision will lie before decision.
My lord, the petition is seeking for conversation.
Application. Let consider the petition seeks to withdraw the present petition to avail appropriate remedy under law with the aforementioned liberty. The petition is disposed of. Petition is disposed of.
I thought 68 a compromise with both parties.
68.
And also report my lord earlier occasion, my lord, the coordinate bench asked the state council to obtain instruction regarding whether the 498 case and the petitioner and also the informer residing together. But their report has come, my lord.
They are staying together.
They are residing together happily.
Where are they?
Because I was report I said.
I want to speak.
In my report and also affidavit Aadhaar card, you not see disposal.
Right. Existence of opposite party number 2. Existence of opposite party number 2, FIR number so and so came to be registered against the petitioner. Petitioner number 1, husband MD Amjad Khan. Husband to MD Amjad Khan, Karim Khan, and
and special 2 also.
Petitioner number 1 is the husband of opposite party number 2, whereas petitioner number 2 and 3 are the father-in-law and mother-in-law.
Read as mother-in-law.
Father-in-law and mother-in-law. The dispute is arising out of a matrimonial discord. the petitioner, opposite party number 2 and the petitioner number 1 and who is appearing?
I am appearing for the informant Miller.
OP2.
Who are they?
OP2 Miller. sir.
Hakim Khan appearing and Badrun Habibi.
This is a community.
Model.
कौन लो? Next paragraph. Petitioner 1 and 2 are appearing in the court today. They are being identified by their respective counsel. They are filing the self-evident copy of so and so, so and so, so and so. The matter, next paragraph. The matter was earlier taken up for hearing by the coordinate bench on 24/2/2023. 23. Notice was issued to the opposite party number 1 state, and direction was made to ascertain as to whether direction was made to seek instruction through the IIC Kendrapada Sadar police station regarding the factum of settlement between the parties, and as to whether opposite party number 2 is voluntarily making the statement and whether she is staying happily with the petitioner under one roof or not. Mr. Ragada appears for the state and submit the written instruction issued by IIC Sadar Kendrapada. As per the written instruction, the IIC has verified the fact that the petitioner number 1 and opposite party number 2 are happily residing under one roof as a husband and wife. The written instruction is taken under in view of the written instruction and keeping in view the order passed by the coordinate bench on 24/2/2023. That Mr. Ragada submits that there is no legal impediment in watching the FIR, taking into consideration the aforementioned facts and circumstances, the FIR number so and so, and consequential proceeding arising therefrom are quashed for the petitioners. Okay. Yes. Next. Yes, sir.
Informant before Miller file an application for cancellation of bail of the opposite party number 1. Invoking that 439.
Who are you?
I am the informant.
You are the informant.
Yes, ma'am.
And what had happened?
Lord,
I
I have lost. Let me analyze the issue.
My lord, OP number 1 has let me finish.
That must be a discipline.
Let me finish.
Yes, tell me.
My son has been murdered by 3 to 4 assailants. I lost the affair. Prior to the date of occurrence, or on the same day prior to the occurrence, these 5 to 7, 8.
What did you pray? Come to the prayer.
I prayed for cancellation of bail of the opposite party number 1.
Cancellation.
On the reason.
Who has granted bail to
the learned session judge. The learned session judge has granted.
On what ground of cancellation?
He has granted the bail.
And you ask for a direction to arrest the opposite party. No, I
Yes.
can't give a direction.
Why I am saying? The language is that High Court or the Court of Sessions may direct that any person who has been released on bail under this chapter be arrested and commit him to custody.
Sessions Court has
Yes.
granted bail. Have you moved application before Sessions Court?
No, before this one, what I have moved. The reason that the learned session judge has granted the bail without verifying the charge sheet. I mean, during the process of investigation, the learned session judge has granted the bail. When the learned session judge has not verified the charge sheet at the stage of
How
investigation.
many accused are there?
There is 8 persons.
What is the role of Rudananda Jena?
I am the informant.
What is the role of Papu?
Papu has committed murder. Eyewitness stated that the Papu has assaulted.
What about the other accused persons?
Other accused persons, they are in custody.
And he is the only guy who has got the bail.
2 person has got the bail.
Papu and
Papu and another man is Bablu alias Aditya Mudun.
you have not challenged the state.
I have challenged. Second item. Item 60.
60. This
Yes.
is 59 and 60.
Yes, ma'am.
Yes, what are the allegations, Justice?
Allegation, yes. Your Lordship may kindly see the. I have annexed all these statements. Your Lordship at page 60.
Why state is not coming?
State, my lord, it is up to the priority of the state to take off permission
Yes,
from DPP and to.
Well, question is, it is the honorable court to decide to whom the bail will be granted or whom the bail will be cancelled. Whatever may be the materials before the court, if the court comes to a conclusion that this order should have been passed, then nobody there to oppose. Nobody there to oppose. And the order has been passed. After giving the conditions, if this condition has been violated or any other condition which has not been complied by the accused person, then only the state will come forward or whatever may be, either the state or the informant will come up. They come up for cancellation of.
But he is challenging the order as such.
No,
Forget about
that order itself challenging that order is no way, Milord. Because how could one person will come forward that yes, this order should not be expected from the court. One should not challenge. This is my humble submission. But the condition, anybody can challenge, either the informant or the state. If it is violated. But the constitution of the court cannot be challenged.
No,
This is the constitution of the
language, my lord, that so far the state of Bihar versus Rajwal of Prasad case, your lordship has dealt that 2017 Supreme Court. It is a discretion of the court to grant the bail. But the discretion must not be extraneous. Discretion must not be beyond the records.
That's always been.
When, my lord, the charge sheet has not been submitted, it is a case under section 302. It is a case, there is an
Where is the charge
eyewitness.
sheet? Show me the charge sheet.
Yes, my lord. I have annexed that charge, entire charge sheet. Page 74, my lord, kindly see.
74
of the brief. Under the above facts and circumstances of the case, as prima facie evidence is well made out under section 302, 148, 149, 120B, IPC, and 2527 against the accused person, Papu alias Pradeep, the present person, son of so and so, Nanda alias Prafula Kumar Sahu of
Show me Pradeep Kumar Sahu. What is the role of Papu?
Yes.
Pradeep Kumar Sahu?
My lord, so far 27 is concerned.
Relative to Papu Kumar Sahu, there was a strong ill feeling between Papu Kumar Sahu and his members from his way. Read the
My lord, your lordship turn to page 70. One of these
73. Come to 73.
Pardon? 70.
73.
Three. Yes, ma'am. Yes. My lord, so far the investigation, during investigation it come to light that prior to occurrence it so and so, on the written report complainant Prasanna Kumar Sahu, the brother of the accused Papu Pradeep, one case has been registered against Mithun, the deceased, and other side, other PSK so and so, under section 147, 48, 341, 323, and said. Also, next date, the written report of Ranjan Sahu, elder father of accused Papu Pradeep, the PSK also registered against Mithun and Nithun. Further, PS case number so and so registered against Mithun.
and subsequently written report of Prafullo Kumar Sahu.
Come to the allegations.
Yes, allegation
Take
may
up
not at the first annexure 1 FIR.
in between that second paragraph. On 19/6/2021 at about 7 p.m. while the deceased Mithun
19?
so-and-so
Yes.
along with his friend
Along with his friend,
Bapi
Bapi
Manas
Manas Ghade
sitting in front
a
of portico of so-and-so
GKM Eye Hospital. Sorry, ma'am, I am
all
reading
of
that.
all of a sudden, the above noted accused person
Accused assaulted the deceased
brutally
Mithun
assaulted
Jena,
the deceased.
armed with deadly weapons, Telenga Kotori, for which he succumbed to the injury at the spot. After occurrence of the accused, persons fled away from the spot with their weapons of offense by using their motorcycle, concealed the weapons of offense in different places, took shelter at different hideout. The accused person admitted during their interrogation that one Sudhir Parida, cousin brother of Papu alias Pradeep Kumar Sahu, had made the conspiracy to cause the murder of deceased Mithun Jena. The call detail of the accused persons also corroborated their statement. The local witness present near the spot.
How many years he was in custody, Papu?
Papu is very 2 to 3 months only.
4 months, my lord.
4 months.
May I submit?
How have you got bail if the other accused persons are there? You are the main conspirator.
No, my lord.
You were
That case has been charge sheeted, my lord. Trial has been commenced. 13 out of 30 witnesses, PW witnesses, 13 witnesses has already been given their deposition. Your lordship kindly see the deposition. As well as informant also.
Anybody has said
Yes, Hudananda, who is the informant in this case, my lord. Kindly see the statement of the Hudananda.
সেটা ভাঙিয়ে দিলে নি কোটা
পুরা পড়িবি না
I am Lodge.
117 matters are there.
Lord, so far trial and
He
bail
has
is
never
concerned
seen
is
the
completely
occurrence,
different.
No, if when the bail was granted,
Bail was granted, my lord. I have annexed that order
My
at
lord,
page 76. your lordship.
21.
Yes.
My lord,
Why should I enter
Papu was arrested on 21/6/21.
You
And
show me the
my lord, I'll
much water has flown under the bridge.
In the meantime.
In the meantime.
But fact remains, my lord.
See, a discretionary order, he could not have got the bail at the first instance.
Yes.
According to me. Because the
Because the
allegations are very-
postmortem report.
But discretion is exercised by the
Yes,
court
yes.
below and bail is granted.
And
the-
without
that
verifying,
remain,
my lord, my humble
that
submission.
remain unaltered for 2021, October 21 to till today.
No, no,
Much
I-
water has already flown.
No,
under.
I have
Why
filed,
should I enter?
I have filed the cancellation in time.
My lord, Hudananda
And
Jana,
court has issued notice.
Yes, yes. Tell
who
me.
is the informant in this case, my lord?
Yes, tell me.
PW 8. Your lordship kindly see para in this cross examination para 5, my lord.
Para?
5.
Yes. Read it out.
It is a fact that I have never neither mentioned in FIR nor stated before police that Bapi Ghade informed me. Bapi Ghade, who was present before during time of occurrence, my lord.
Informed me about phone.
Over phone that Papu, Sudhira and 4 to 5 persons have killed Mithun.
It's not a fact that I have neither.
It is a fact that, my lord.
Yes, that's the.
But eyewitness
And
was
another
there.
eyewitness also.
I'm
Lord,
not
there are-
conducting a trial.
I have not.
Your
I have
lordship,
not submitted
another
the-
eyewitness, Bapi Ghadai, he has stated before they have never seen.
Now you just see,
Yes.
the evidence has come.
Let
That time maybe you are correct, but today, said those evidences come.
And tomorrow, my lord, tomorrow the
And
date is
please-
fixed of our hearing, my lord.
The father of.
May I submit one thing
victim, yes.
before the section? Fact remains, while the London trial court has.
At that time, you are correct, 100% correct. I am 100% with you. But today, now these evidences has come, wrong, right, whatever.
I am bound on it.
How can I cancel
But-
it? You tell me.
My lord, the question is now they are threatening me too, because I have kept the pleadings.
Registered a case and file a cancellation.
Your lordship may kindly see.
That
They have never violated in during the time of bail, they
Sir,
have
let me
never
complete.
violated.
But that's not cause. They see, on merit, you are saying something. Merit, you see, you have
Your
filed
lordship
on-
may kindly see paragraph
you
13
have
of.
filed this petition on 22nd April 2022.
Correct.
It was remain pending. What to do? That's the system of. You are a victim of a system.
Everyone is victim of the system.
What to do? That's the whole difficulty. Why have you taken a lot of adjournment here?
I have not taken adjournment.
Three
I
hearing.
never take any
What
adjournment.
is
My,
this
my,
matter? Three hearing.
my lord and brother has taken adjournment. I never adjournment take.
These matters immediately should be done.
Yes.
You allowed him unnecessary,
And-
these things have come now.
Your lordship, can you see the PW4? Who was,
Let us-
who,
Now the present accused two persons, they are threatening the other witnesses.
I will record that and
Yes,
if
and if
you proceed against them, if they do it.
Yes.
You can't do.
Yes, my lord. Yes, yes,
Petitioner had checked,
then
the order dated.
if
Order
person
dated.
was committed murder will scot free.
Order dated 11/10/2021, whereby the opposite party number 2 has been granted bail. The opposite party number 2 is an accused in
OP number 1.
opposite party number 1
One,
is
one.
an accused in FIR number so and so under section so and so. The reading of the charge sheet indicates that the opposite party number 2, there are allegations against opposite party number 1. Allegation of opposite party number 1. Mr. Mishra read out the charge sheet and postmortem report and submits that in view of the serious allegation, the opposite party number 1 was not entitled to bail, and the order is palpably wrong on merits. Hence, he seeks indulgence of this court to cancel the bail. Mr. So-and-so appears for the opposite party, submits that after the bail was granted, his client has cooperated with the trial, and meanwhile, 13, how many witnesses? Meanwhile,
No, my lord. I have never.
what I'm asking, how many witnesses?
My lord, 13 witnesses.
13 witnesses. Examine. The
Out of
present
30, my lord.
petitioner, the present petitioner who was also examined on 11/5/23.
But tomorrow also.
In the cross examination, the present petitioner, who is the father of the victim, has entirely stated that inverted comma. It is a fact that I have neither mentioned in FIR nor stated before the police that Bapi Dhodai informed me over phone that Poppu, bracket the opposite party number 2, opposite party number 1, comma, Sudhira, and 4 to 5 others have killed Mithu. Inverted comma, close.
My lord, may I submitting, my lord?
1 minute, let me complete.
My lord, another Bapi Ghadi who was during the time of occurrence present.
Am
He
I
has
going to record an acquittal order?
He has already
I'll
declared.
cancel the bail. then.
My lord.
Why are you unnecessary getting in? Apart from that, other witnesses have also not clearly supported the prosecution case. Since much water has flown between the date when the opposite party number 1 has been was granted bail till date, I am of the considered view that no interference is called for. At this stage, Mr. Mishra submits that after the bail was granted to the opposite party number 2, they are threatening the witnesses, including the present petition. If the opposite party number 2 is indulging in such activity, it is the petitioner is free to initiate appropriate proceeding or a report to the police in accordance with law.
Yes.
You report to the police and after
Yes, my lord.
with this observation, the petition
Both.
you should immediately have
Lord,
given
I
a
should
complaint
not-
to the police.
My lord, I should not say anything because we are succumbed by the systems itself.
That's the biggest problem. Everybody is a victim.
Pardon?
Everybody is a victim out of it.
Yes,
And there are a few people taking advantage of this also.
that I cannot say.
59-60 both.
Both.
Again. 61.
My lord, may I please? No, I'll do, I am for the petitioner on the
You mentioned it in the morning for adjournment.
On the morning, I have mentioned that that matter should not be adjourned. Your lordship.
Okay, there is an opposition. Come, let us argue. Argue.
Next week, my lord.
He is opposing, what to do? Here.
So many dates.
The matter is adjourned many times.
No, my lord. On the request of them, my lord. Not a single day I have
yes,
asked
tell
for
me.
that. But this is for a cancellation of bail, my lord.
Cancellation.
Only on the ground that without taking into consideration the gravity of the offense, the law and code below.
What is the gravity?
My lord, 376.
Who are you?
I am the victim, my lord.
Krishna Bhuya.
My lord.
29. What are the allegations?
My lord, the fact is that
Hmm.
after registration of the case, the petitioner came many times to this honorable court. In BLA, my lord, my certificate given I am that, and also a death cert I have also.
What is the allegation, you tell me first?
Allegation is that giving false assurance of marriage. He took physical relations
You
with.
know, you have been
No, my lord, when I was in 16 years.
Where is that?
My lord, my 164, I have not annexed, my lord. 164. My lord.
If you have not annexed, where from I?
For that reason, 4 POSCO has been registered in case has been registered.
Show me some evidence where.
My page 10, my FR.
You are asking
एफआईआर
for
नहीं
cancellation, you
डेट
can't
अनुसार
file
आपण
anything.
कोन प्रूफ कर दियंतु
हाँ?
डेट अनुसार डेट अनुसार प्रूफ करिया दरकार ए खाली एफआईआर देखि किछि लाभ नहीं
My lord.
नो
Want
यूजफुल
cancellation of some. See, a right has accrued and he is at a liberty. You want the liberty be taken out.
My lord.
And you don't file anything.
My lord, everything I have filed. Everything, my lord, kindly peruse my death chart.
हां डेट चार्ट
My death chart I have filed. My lord, my death chart I have given.
Yes.
Date of occurrence, my lord, 22.
Petitioner came to have pregnancy.
2010, the occurrence. These 4 to 5 times the respondent note 2 has approached this honorable court. All the applications have been rejected by this honorable court. Bail applications, also 482 application. Thereafter, the learning sessions was plead to allow, my lord.
Where is the order of bail?
My lord, page.
अरे এটা নো
Page 27.
27.
Only because after vacation of the stay order, the respondent note 2 appeared.
Read the order granting bail.
Yes.
My lord,
that is important.
operative part, my lord, page 27.
26 para 3 minute.
1 minute, he let him read.
27, man.
Read it.
The accused, my lord, 9th line from top. 27. The accused has voluntarily surrendered before this court after a vacation of the protection order of the Honorable High Court. Thereafter, he has a permanent residence. A law and defense counsel certified there no bail application. Hence, I take a lenient view to release the accused on bail. Accordingly, the bail petition is the last towards end of the para, which is allowed.
Importance is there. I'm reading law. From the
fine has been rejected and challenging that order, I have came before this honorable court, my lord. And here, my lord, the petitioner
Convicted under section
395 only.
395.
Yes,
What
my
is
lord.
the sentence?
And custody is
What is the
7 years.
sentence?
7 years.
7 years.
And custody since 26/6/2023. 10 months.
389 benefit is not given.
Not given, my lord.
Where is the judgment?
And that is at annexer 2, my lord. Your lordship may kindly see. This order I have challenged on page 10.
Where is the conviction order?
Conviction, my lord, sentence. I could not find.
সেটা কিছু ফাইল করে না কেবল
File করনাহাନ୍ତି কଣ?
অর্ডারটা ফাইল করছে
Judgment file করছে, let it come next week. I am serving a copy, my lord.
I am searching for that. Okay. Urgent.
জজমেন্ট
Arjan, my lord, office ରେ file করছে.
না মতে দেই দে সেটা ফাইল
It has already been taken into custody.
Yes. He's in custody since June 2023.
Undergone how much?
10 months, my lord.
10 months. And 25,000 rupees default, you have deposited.
Not deposited. Stay fine till disposal of appeal, my lord.
You deposit that and come.
My lord, 25,000.
25,000 deposit.
unknown affair, tapare kichhi TI parent nahi kichhi nahi.
7 years plus 25,000.
Yes, my lord. 25,000.
389 appeal is admitted.
Yes.
389 concession is not given.
Not given.
That's what he
Yes, yes.
according to me, you deposit 25 and come and
25. I could not
10 months he has already gone.
I could not deposit.
It is bail
Labor-
application in disguise.
Yes, labor class people I could not deposit. My lord, if convicted, then my lord, other.
You are already convicted.
Yes, but in appeal, if my lord, if my
So the prima facie case also.
yes,
Let us
yes.
see the prima facie case.
Yes, my lord. I am serving the my lord, the judgment copy, my lord, to the State Council and also my lord, your lordship. This is the copy of the judgment I have filed. Only 10 witnesses examined.
You have kidnapped 3 persons and taken away their
Seven,
vehicle.
yes, FIR against 7 unknown persons and
Okay,
all
you
of them.
file it, we'll see. File it.
Yes.
File it on record. Let counsel for this. The petitioner seeks to file additional document to substantiate his case. He may do
Copy
so
of the
to-
judgment, my lord.
Whatever. Sir.
My lord, I will file in office, my lord. My lord, I have served a copy. Your lordship,
Yes,
kindly-
serve the copy.
Yes, yes. No, I have already served. Your lordship may kindly note, my lord.
Yes, next.
Maybe taken up next week, my lord.
He will give you.
I will file today, my lord.
Next item. 63. Yes. Urgent, May.
Arjun.
64. Here.
Wait, please, your lordship. Well, the petitioner has sought for a setting aside a bail condition, my lord.
What is the condition? Show me.
Page number 11, my lord.
11.
My
Yes.
hard condition. He shall attend before
11, 1 minute. He shall
attend before the IAC Collier PS once in every month, preferably on a Sunday for a period of 6 months.
every month, preferably on Sunday for a period of 6 months. What is the
My lord. My lord, the petitioner was released on bail in a 389 CRPC in appeal bail, my lord. Appeal bail. During the pendency of this case, the petitioner is an employee of MCL. Now he has been transferred to Sambalpur. He has got a quarter and permanent residing in Sambalpur, my lord. And the
this order was made on 25/1/24.
24, my lord.
How many times you have 21?
I have appeared, my lord. In the last 2 years, a month has elapsed from that day, and I have appeared, my lord.
Every month once only. Sambalpur.
Well, the difficulty.
And this is which place? Sal. PS Sal. How far it is?
PS.
from Sambalpur?
This is in PS Collier, my lord.
Collier PS.
Collier PS.
Collier.
Petitioner is in Burla Sambalpur.
Collier. Acha. Collier. Acha. Sal le PS. Collier. How far it is?
Around 300 kilometers, my lord.
Monthly once. Yes.
My lord, my contention is that even the trial is over and there is also no possibility of me fleeing from the jurisdiction of the court or threatening the witnesses, my lord. So I said I submitted.
Yes, Mr.
ସେ ଯୋଉ ଥାନାରେ କହୁଛନ୍ତି ତାଙ୍କ ଇଚ୍ଛା ଅନୁସାରେ ସେ ଥାନାରେ ଯାଆନ୍ତୁ
ଆମେ ରହୁଛୁ ଗୋଟେ ସେଟା ବୁର୍ଲା ପିଏସ୍ ର jurisdiction ରେ
ଯୋଉଠି କହୁଛ ସେଠି ଯାଆନ୍ତୁ
ଠିକ ଅଛି ବୁର୍ଲା ପିଏସ୍ ରେ ଆମେ
Okay.
ସେଟା କହନ୍ତୁ
The petitioner is assailing the order dated. Petitioner is agreed by the condition imposed by the court below while admitting the petitioner on bail. While order dated 25/1/2024. The petitioner is agreed by the condition, by the third condition, namely, the third condition, he shall attend, inverted comma, he shall attend before the IIC Collier PS once in every month, preferably on Sunday, for a period of 6 months. For a period of 6 months. Then counsel of the petition submits that the petitioner was earlier working.
now also working in himself, earlier working at Talcher.
Earlier posted at Talcher.
MCL Talcher.
MCL Talcher. And now he has been transferred to
CWS bracket X IRB Valley Sambalpur.
जोर रे को भाई ट्रांसफर तो जोर रे कहबो
CWS
ସେଟା annex 2 ରେ ଅଛି
Annex
page 13
page 13 लिख दिया.
yes
Page 13.
Therefore, it is difficult for him to appear before the IIC Kolari PS.
Yes.
He wants modification of the said order to the extent that he shall be appearing before
The Burla PS.
Burla PS.
Yes.
Every month, preferably on a Sunday. Preferably on a Sunday. With this modification, the present petition is allowed.
My lord, the certification be transmitted to the court, my lord.
Yes, yes. Your IIC is directed to transmit the certification to the concerned court.
The IIC Burla
Yes.
shall transmit the certification to the
Concerned
concerned court, namely
Additional sessions just dalche.
additional sessions.
In connection with this.
In connection with
TS case number 8 of 2020.
CT bracket S case number 08 of 2021.
Well, part file, because the trial is over, it is a part file. They have opened
সেটা
part.
এটা থবে না এটা থবে বলে ও না এ আছে
যাহা লিখিও লিখে দিও ভাই
part file লেখা
হ্যাঁ পার্ট ফাইল
Part
ও
five.
ব্র্যাকেটের ও পার্ট
part
ফাইল
file লিখে দিও চলো নেক্সট
Oh, bless me.
69 69
69 আচ্ছা ভাই না
there was somebody was mentioning he is not well, so he was seeking adjournment. I said wait because the gentleman was not well. I'm sure. 70 Okay, 70.
This case I prefer adjournment because the last occasion the petitioner and OP number 2 were professional present, and the OP number personal appearance OP note was dispensed with. Today the petitioners could not come, my lord, because it was
Petitioners are the accused.
petition is that.
Settlement has taken place. That's what you are saying. Settlement is taken place. Where is the petitioner?
Petition number 1 was Naklodas, was the husband, my lord.
It is a case of 307 and all.
Yes, my lords.
We can't wait for petitioner like this. We are not under the mercy of petitioner.
One
It is
more
a settlement.
A settlement they
And
have
he
filed.
should have come.
My lord, they have filed the affidavit. They both joint.
So why can't they come? Court will wait for them.
No, my lords. It was fixed to 27. That there was no court. Thereafter, case was listed today.
Call them tomorrow. Otherwise, I'll dismiss it.
One
Call them tomorrow.
day after tomorrow, my lord.
Day after tomorrow. Call them day after. 71. Day after tomorrow, call them. This will be there. I'll dispute it. Okay.
Please, your lord.
Yes.
Item 71, my lords, I am for the petition. My lords, here what has happened is a 480.
Before my submission, my lord, I am submitting the opposite party approach before the Honorable Supreme Court, my lord, challenging the order of the judgment, my lord, dated passed by this Honorable Court, my lord. That is sub judice, my lord, and
which judgment?
My lord, earlier, my lord.
On
And
what?
this is
Your lordship will understand if I will explain it.
And he says that he has.
No, that is not under dispute here. I don't challenge that order. What I say is that when the matter was sub judice before your lordships, and your lordships had reserved the matter for hearing, the complaint was filed before the SDJM without disclosing. The opposite party did not disclose about the pendency of the matter in this honorable court. And notice was issued, my lord. Cognizance was taken against us, my lords. Your lordships have quashed that order subsequently, which now they have gone to the Supreme Court against that.
Which order? Which is the order which is quashed?
That order I have annexed, my lord. Your lordship may see annexure 4, my lords. No, I'm sorry, it's not annexure 4.
6, my lord.
6.
Yes, annexure 6, page 50.
8.
Yes.
The lordship may see page 56, my lord. That is the order. Now, the informant complainant, she was a party here. she knows very well, my lords, that the 482 application has been heard and is pending for orders. Without disclosing that fact before the court below, my lords, the fact that the investigation and proceedings in the complaint case had been challenged, she files a petition which she styles as a protest petition. That is Annexure 1, my lords, at page 24. And an order is passed, my lords, which now I have challenged, my lords, at Annexure 2, my lords.
So any case now, since you have an interim order, let us wait what are the.
Yes, I don't dispute that. But my lords, how can somebody who is a party here, my lords,
I will not write because that
disclose
has nothing to
and
do
then
with
go
this.
to the apex court?
That's
surprised.
the pendency of SLP has no bearing on this.
Exactly.
So, but if you want an adjournment, simply I adjourn interim order to continue.
My lord, lordship fixed date, my lord, the
Then counsel for the opposite party seeks an adjournment on the ground that a connected matter is pending before the Honorable Supreme Court.
No, my lords, my submission is if this connected matter will create difficulties, they will cite this order, my lords, in the Supreme Court saying that
absurd. I will not say anything then.
yes, your lordship did not say anything.
Unnecessary.
he is a metal, my lord.
Let a counsel for the opposite party seeks an adjournment. Let the matter be listed for final hearing on services day. Interim order to continue.
My lords, obliged.
73.
Date may be, lordship may.
He'll give it.
My
He'll
lord.
give it. Meanwhile, just pursue that whatever.
My lord.
Okay. Yes.
73.
Yes, 73.
Lordship, in item number 73, I am appearing on behalf of the opposite party accused, Lordship. Today I have filed my Vakalatnama, Lordship. I am praying for an adjournment, just a short adjournment.
What is this matter?
Matter, Lordship, the petitioner is a complainant before the complaint below who has launched the prosecution under section 138 of the NI Act against the accused person, Lordship.
Who is for the petitioner? Who is for the petitioner? Is there any interim order? You are for opposite party number?
2, Lordship, Chittaranjan Panda.
You are the complainant.
I am the accused before the court below, my lord.
Accused.
Yes, my lord.
Then okay, simply attend. He is the complainant, is none appear for the petitioner. Mr. Pravas Pujari Parida appearing for opposite party number 2 seeks an adjournment. Urgent 2. Next time.
74.
Lordship, on behalf of Mr. P.K. Padhi, I pray for an adjournment.
I am for the informant, my lord.
Yes.
The
There is an
petition.
interim order.
Yes, Lordship, of the interim.
You have no opposition.
My lord,
You have no opposition.
I have objection, my lord. In this case, the petitioner has challenged the order of a cognizance and the entire criminal proceeding pending against him. But the learned magistrate, cognizance taking magistrate, has not committed any error, my lord. In taking cognizance of offense punishable under section
See, what is your grievance that NBW is issued against?
Yes, your Lordship.
I'll set aside the NBW and go and appear.
Yes, your Lordship. That is the prayer, your Lordship.
Let him go and appear, whatever you want. Huh?
Yes, your Lordship. That is the
NBW. Okay, I'll set aside. You are
Yes.
on bail?
No, your Lordship.
This would be rejected.
Rejected. That was rejected, and the
And
interim.
NBW issued. Anticipated
My
reliance,
lord, three
rejected and
SPs,
individual
your lordship, 294, 341, 323, 324, 307, 506 of IPC read with section
Will
3.
you be happy if I set aside this and ask you to go and appear and avail remedy under law?
Yes, your lordship. If the order of cognizance, if the NPW is first, your lordship.
Usually your lordship passing that type of.
Right now,
Yes.
the petitioner is agreed by the order dated 27/9/2023, whereby learned special judge cum sessions judge Gajapati has issued NBW against him in GR case number 27 of 2023. On instruction, learned counsel, the petitioner submits that petitioner would appear before the learned court below on or before 30th of April 2024 and seek remedy available to him under law. Taking into consideration the aforementioned submission made at the bar, the impugn order dated 27/9/2023 issued by the special judge cum sessions judge Gajapati in GR case number 27 of 2023 squash, subject to the petitioner appearing before the court on or before 30th of April 2024 and move appropriate application under law.
Grateful.
With this observation, the petition is dismissed.
75.
Mr. Raghunath, just see, these are the revision petitions.
My lord.
And we'll see if there is an interim order, you tell me.
No, against conviction.
Noting is for addition. My lord, if my lord, it may be mentioned as a hearing, my lord.
Yes.
So that everybody will prepare, my lord. Instead of a.
It will be released on bail on certain days. Will read. See, yes, you tell me what is.
Yes, against the confirming judgment, it was the annexed to page 20.
What is the conviction?
That SI for 6 months and fine of 1,000. First offender, no
What
incidents.
is the offense?
323 and 34 IPC.
323?
3 and 34 IPC.
How much you have undergone?
That,
Undergone.
no, initially,
Undergone. 323.
yes, initially April was
Available offense.
valuable offense. He was throughout on bail. during
Jail
that.
kete goleni apno.
No, to that effect.
Jail roichandi ki nahi?
No, jail jaina to. Only FR was also 294, 341 and 34 IPC.
For kete din roile? Kichhi nahi.
Nahi.
2 years.
Padapat mil gaya na.
Less
Ah, yeah,
than 3 years ale bail millions.
Up to 3 years.
3
generally.
million benefit mil jaye to.
Ah, yeah. And confirm in appeal. First offender having no incidents and due to previous dispute, lost this affair. And the lordship see.
So show me the allegation.
My lord?
Show me the allegation.
Allegation, yes. The lordship, the trial court judgment at annexed
It
to
is
page
sentence
14.
and fine also both.
Yes, fine of 1,000 each. Both petitioners are 2 in number.
Here or with fine.
Yes.
So I'll maintain conviction and you pay the fine. Fine or hai. Sentence or hai.
No, fine is there. Or is there.
Or is there.
Yes, or is there, madam.
So 1,000 rupees pay and finish up.
Yes, that will solve the proposal.
It says that the
Yes.
imprisonment for either description
SI for 6
term,
months or
it
fine.
may extend to 1 year or with fine.
With fine. That is
Then
there.
conviction maintained, sentence reduced down to 1 year. So 1,000. Fine of 1,000.
As yours.
No, allowed.
As yours.
Allowed to partly allowed. Partly allowed.
Sentence already.
I'll give the judgment. I'll give the judgment. Sentence reduced to fine of.
No, it already undergone and fine is. It already undergone if you need.
Period already undergone. You have not undergone.
Of course, of course.
That's
That is there. Converted to fine. Or with both, that is there. Alternatives.
Sentence is converted to
Fine.
Fine of 1,000.
Yes, ma'am.
Fine of 1,000 rupees, conviction maintained.
Yes, sir.
चलो, conviction maintained, sentence 1,000. Disposal. So, आगे. Unnecessary spending all these things, nothing is there. Yes, next.
Please, your lords.
Hmm.
Petitioner was convicted under section 138 NI for 1 year 1 year SI and fine of 1 lakh rupees, which in appeal was modified to 1 month SI and 1 lakh compensation.
1 lakh compensation you have paid.
No, Lordship, it
Pay
was
1 lakh compensation.
Lordship, there are grounds.
Forget about ground rule. 138 pay 1 lakh compensation and where is the opposite party?
Lordship, in the check, my signature is.
But you are convicted. No. That presumption again, strong presumption. Who is the opposite party?
Opposite party is not there.
Hmm? Opposite party has to be here.
Yes, sir.
Urvashi to store.
Yes, your lords.
Is the opposite party?
Yes,
Who is
sir.
the opposite party? You have included a state only. Where is the opposite party?
Opposite party is Uttarani Shoe Store.
Huh?
Notice.
Where is that? Acha, Uttarani Shoe Store.
Shoe Store.
Who is appearing?
Notice at one.
Issue notice to opposite party number 1. Huh?
Yes, sir. Not notice has gone.
Who is appearing for the court notice issue? Order number? Notice issue ki advocate ki. Huh? Paper case. Check is issued on. Check was issued on.
Check was issued.
Check dishonor case, you don't know when the check was issued. Huh?
Say 2000. Check was issued on 22/12/2005.
What was the check amount?
65,000.
65,000. Will you pay that amount?
No, your lordship, because in the statutory notice, the check number is defective. The notice 138 notice.
You have reply.
It's been.
Statutory notice reply have you given?
No reply was given.
You are not sure about anything. That's the.
For the how
don't give reply to the statutory notice, then presumption operates.
But how the legal liability accrued, that also is not being no document in respect of that was exhibited.
Show me where is the judgment, which part of the judgment? Impugn judgment. Are you ready?
No, lordship, maybe adjourned.
6th. On 6th, no further adjournment. I will appeal you.
May I interrupt, my lord?
Yes.
In fact, both the petitions are fast offender, having no antecedents. The learned trial court as well as appellate court refused to extend the benefit of section 4 of the PO Act on the ground that the victim is a lady and both the accused persons are male member. You also see that
Which one you are talking about?
that 75. I'm sorry, my lord, that
It is over already.
that
I know
benefit of PO Act is to be extended that.
Only one for 1,000 you are
As
talking.
you also.
Yes.
Because both the court below refused to extend the benefit of PO Act. As you also.
Instead of going to sentence, imprisonment 6 months.
Give 1,000
he has to
rupees.
only-
Yes, next. 77. 77.
77 milots is an order of conviction.
Hmm.
Sentence is for 2 months. Offense is 379 milots. Read with
379.
again. Read with 34 milots.
What is the sentence?
Milots 2 months milots.
2 months. Already undergone? How much?
I don't have instructions to that effect.
You were arrested for some time. You tell me undergone.
Again.
How much undergone?
Milots, I'll have to take
Sit
instructions.
there and tell me. Wait.
I don't have the LCR.
Take it, give the file.
Okay.
Sit there and check it. Now, tell me.
So I also have a ground, my lords. That
Forget about ground, you tell me.
Lords.
Yes. Try and let us finish some matters. Unnecessary small matters. Yes.
78 Lordship 379 IPC he was convicted, which was upheld 2-year SI and fine of 1,000 rupees.
Undergone?
Undergone 21 days.
Huh?
Lecture. देखिए
Put the record 21. 21 means 1 month about.
21 days.
21 days about 1 month.
अच्छी बात है देख वेरीफाई करो ना लॉर्डशिप दैट इज नो लॉर्डशिप दैट इज
Further Lordship, the person might have been 81 and above, 81 years old. Whether he is alive or not. 2011 after.
So then, you come on 6th, verified. 6th. And note karo 6th. And you tell me that day, 28 days he has already undergone.
21 days.
21 days and 379, what is the extent? Three years.
3 years.
Which may extend to 3 years.
May extend.
Or with pen. It's all right. Already undergone if he survived. Just verify and tell me.
Yes, sir.
Get the definite information, huh? Okay. Next.
6-3.
6-3. Yes.
79. 79.
79. 79 দেখুন তো পেপার এটা কোন হইছে
78 confirmed at 21 days custody.
হ্যাঁ
ये देख ले कौन है
24/1/2011 to 24/2/2011.
দেখি দেবো তারপর whether he still survives or not, that is no? What is the next thing?
Visa.
2011 50 years ଥିଲା ବର୍ତ୍ତମାନ 60. Court notice to who is appearing for the petitioner?
Nobody is appearing.
Who has entered appearance? B. Sahu. Huh? B. Sahu. Court notice. Issue court notice. Huh? To the counsel for the petitioner. 6th. Yes.
नहीं 8 कोर्ट है भाई
वकील लोग तो देबे
8 तो बार ना
8 तो सब एडवोकेट को देबे ना कम से कम स्ट्रीमलाइन तो करियो ना थ्रू ये
रजिस्ट्री देबे
कोर्ट नोटिस टू द लॉयर यस
मतलब थ्रू रजिस्ट्री 80
yes no it's same court notice 682 yes
82 is concerned, my lord. This is acquitted under section 376 and convicted under 366 4 years, my lord. If prayer lordship can keep it to 16 so that I prepare
16
16
16 रख दियो 16
23
83 I am for the opposite party.
Opposite party.
20 days delay to appeal. Petition copy हम पर नहीं.
Sorry.
20 days delay আছে delay petition.
Forget about delay now.
83.
After 22, after how many years you are questioning delay? What is on merits? What is the case?
बड़ा copy भी नहीं खाली लिम्स petition टा.
What petitioner not appear मतलब Miss Gitanjali Maji non appears but petitioner counsel not there.
Issue notice to the counsel. Yes.
84.
85. Yes.
My lord, on behalf of Mr. Das, Viplav Kumar Das, next week on any day.
6. 86.
May I please ask? In this case, my lord, person has been convicted in the offense for 490 day and sentenced under array of array for 3 years, my lords.
498.
490 day, my lords.
400?
490 day, my lords. 490 day.
Okay.
Array for 3 years and my lords pay fine of 1,000, my lords. Petitioner the husband, my lords, and the complaint the wife of the petitioner, my lords, and allegation that my lords.
Convicted. Only the husband is convicted.
My lords.
Convicted. They all
Other persons are my lords acquitted by the land tribunal.
How much you have undergone?
Lords, 2 days, my lords.
Only 2 days.
During trial, my lords. Only allegation, my lords, he brought the younger sister of the informant in the house, my lords. Only allegation, my lords, the present petitioner brought the younger sister.
3049. 498 only.
490. And my lord, the marriage are not proved, my lords. 494, my lords. That is,
What about now? What is the status?
Status, my lords, they are staying, my lords.
They are staying together.
One daughter, one son of the first wife, along with the, my lords, the younger sisters. The first wife, my lords, left the house, my lords. Custody.
This is the FIR by the first wife.
First wife.
He must have been taken to custody twice, my lord. 3 years condition. The appeal stage also the trial stage.
You undergone, tell me.
2 days.
appeal पुणे जाइतो ना 3 years जाइतो ना तो पुणे बेल मिल जातो
बेल अच्छी ना थे
3 years जाइतो appeal कला पर बेल मिलतो और देखी दे
हो जाता ना इंस्ट्रक्शन
वेरीफाई कर दे सर
देखी ना दिया सर देखी सर जाना पड़ना सर सिक्वल during trial he has in bail, my lords. In the appeal, during trial he has in bail, my lords.
During trial bail, after conviction he might have gone on custody. Thereafter 389 benefit might have been extended to you. See, who this? The past wife who was the informant may not be interested also now. Really, 2011 matter. Then 12 years have gone by. What are the material against you? What are the allegations? In favor of the one of the guys. Other people will also suffer. Whatever possible relation are there, try to think of reducing sentence or something. Not one matter will be directed to supply What is this? In 22 delivery 23. 15 to 23. 29 to 24. And 20 March 2020. Yeah, how this is not. And I'm even stop and repeat it. Today when we get to our not, and when it when we use some cases, we go and on 6. 6. Agreement with the ready to actually do. Yes. 90. Yes, that's right. Depends on the amount of anyway. Apart by the additional CC whereby the conviction whereby the go below and confirm the conviction in sentence order dated 6/1/2010 marked by legislature composed in the 150th number 254 public legal to party number 2 opposite party opposite party opposite party yes the complaint has expired. Therefore, since the time to bring the last of the party on record. We can do you give notice, you have been made. He will inform you. Then you will do what? If you give a notice on the 22, 15 or 10, then taking that came to know that he need give him particular of the last, then he'll give it. Then you move on. I'll be moving. What is this matter? What is the offense? Some 341, 307, you know, you have been asking why is it was around 5/3/2024, and then it's around 20th March 2020. On the switch up to the response for the education that was in the again the response of the business seats and network. In the interest of justice, let's say to 66. Immediately that no further continuing. Six times I have given. 6 times decided. It is your work. Saturday, only for revision I have university. Next week. Twice I have given. What is the value of the conversion under? Three and 906. Yes, you don't have those Indian everything else also. Business, criminal, everything. We don't fix it. What is the problem? What is the no, try. What is doing by now? Even if it's difficult, you can find out. Then, Yes. Yes. Last time, say the allowed line, if the line is being misused, we cannot have within the we have no finance. Now read it and tell me next. Yeah, read and tell me what is it. The problem I get it, but read it and tell me what is the condition, what is the sentence by now question. It's there. It's here. Right here and read. Note it down and tell me. Yes. It makes sense. Business. Yes. They undergone how much? 16 years. It is already under. Who is government servant?
One and 2 months.
1 and 2. That will working.
What means? Working as well as the zero to yes. As well as teacher.
What is the case? They be educated.
This means.
Something so that we can equip. What is you have criminal investigation?
No one is.
Yes, I'll just check it up. See, is the government employee 1 and 2, 323 conviction, 1 month. How much you are getting on?
60 days. The tuition of 4 days.
4 days. Anyway, they have undergone 3 days or whatever. They are government employees, their salary will be affected unlike the 3. Permission मिला कर ले चाकरी वाला. It will be something we will do it.
6 minutes.
6. And at the top of 4, 6. Give some material so that we can record in digital and so that job will be safe. 123 minutes.
Next week.
Sure that next week we will what is the case? How are you appearing on 25? Brilliant. Yes. Good is one thing.
I'm for the opposite method.
Which party? How is it? One lakh? 138.
138.
103 na? I can 103.
110. And there's 9. There's 9.
What is this? What is main reason? I can work on the reason station.
I'm for the opposite. Sectional not.
Connected under section 108, huh?
138.
Take it out.
Account is 6 minutes. One is 50,000 and another is 75,000. Total 1,20,000.
Conviction. in one example, writing out of one country is in the traditional person collected. When you put in context, that's when it to 125,000 and compensation amount for not for 500 rupees. So lots of kind of say 7 of them and 12. In the business has been conducted on a sentence. Convicting sentence will be and I have been in the interest of the on that day, I guess. Just give me, it can be converted into 23 and the sentence will be written. On that case, we do this. 1.2.
No instruction.
One second. One second. Are you checking that? In second. I want to I believe. You follow what I'm saying. Like you should have found things second. Call and tell you
In the medical lordship, all the petitions have included the final amount, your lordship. And annexed all the documents.
How many of you are there?
Six, your lordship. Six, your lordship.
High Court.
3 months for the offense under section 148, 6 months for the 324, and 3 years and 9 of rupees 1,000 for the offense under section 326. In the main time of the
Maybe it must be.
it was nice. The except petition number 2, all the petitions remain in custody for 1 month and 4 days. They have been bailed out on 18/7/98, and petitioner number 2 bailed out on 15/8/98, remaining there for 2 months. I have ever in para. I mean, affidavit to effect para 3 of the continuous 2 in the lawsuit. In the meantime, already,
What have you used? Which equipment? Which weapon of offense?
that is, it's anyway, dispute land your lordship. You can do your lordship. Then land dispute your lordship. Land belongs to the petitioner's name, your lordship. The informant is the intruder. That is, that is clear in the evidence of IU, your lordship. In the meantime, already 26 years is already passed. So I agree. So that's because they've already depleted the amount, your lordship, 1,000 each.
Amount they have deposited, one month they have undergone. All of
Section number 2, 102 months. And rest of the sections they have undergone 1 month. Just more than 1 month.
Sentence is there. Really they feel out of this. It means 43.
Yes. No, sorry, it's one more, no, it's also there. Considered by comparable. Oh.
How can we invest into 323?
Yes, your lordship. If your lordship, the document shows that the High Court judgment is internal page end is 17 years.
17.
It says 17, only says 17, internal page 10 years.
17.
Around 8, middle person years.
Correct.
Correct.
In the course of argument here.
I'm just giving 4-5 answers also. Doctor has clearly admitted in its cross examination that he had not done the X-ray of the injured of Bhutta Rao and Rajeshwar Rao. He also cannot say who had done the X-ray and what circumstances the injuries of the injured Bhutta Rao and Rajeshwar Rao were X-rayed. So, the X-ray which they produced, that was not referred by the doctor. And the doctor, in his evidence, that really find all the injuries were simple in nature, except one injury, and which was caused by the hard and blunt weapon. And here, what they seized one axe, and it's not a.
But the act corresponding to the injury.
There is no inside wound, your lordship. There is no inside wound. That cannot be caused by a sharp-cutting weapon. And the specific point
323.
And only the lordship can consider taking into consideration the period of custody. Apart from the conviction part, 3 months, and out of 3 months, already in 1 month.
No, this sentence is 3 years.
2 years, 2 years, 2 years, 1,000, 26.
Reduce the sentence to 6 months.
After around 26 years, 24, 25, 6 years, lordship. And all the citizens are on 62 years and 67 died in your lordship. In 2013,
You give me the details of the petition. We 2013 18.
yes, your lordship.
But Lingaraj 35.
35.
And then the 63,
62.
53, 52, two of them are 67 and 62.
62.
And
By now, all have been crossed more than 50 years. Your lordship. It's
no. 13 means 10 years.
10, 11 years. Your lordship.
11 years. 11.
Sorry, sir. And in the meantime, your lordship, during this period of their bail or during period of appeal,
Keep it on 6 sentences.
6 years.
And give a advance note to the, so that we will finish it up. Advance note to Mr. Maharaja.
Yes.
We'll find out the bail.
And your lordship also exercise the discussion on the PO Act, your lordship, 4 of PO.
We'll see about the PO Act, get some judgment and all.
Yes,
But I will
I've got one Punjab and Haryana High Court judgment.
give it to him. That's Supreme Court also.
Yes, sir.
Supreme Court, this court, if you can give. Okay. 6. Next. 107. Vikram Chandra, court notice 2.
Yes.
Yes. 108. Court notice 2, 108. Yes.
On behalf of Mr. Vacation file taken on 6th May.
6.
I am for it.
Six. Get ready on 6. We'll try to finish. Yes. 110.
On behalf of Vasudas, let me remove it. On behalf of us. Let her one back.
Matter was taken up twice. When concept of the petitioner. 6. One more opportunity. One more adjournment. In the place of justice. Total 11 court notice. Court notice. 130.
That's 112, my senior will conduct it. That's any other date will also be the next one. I have matters on that day. My senior won't be here. Next week, coming week.
I'll get it listed. Let us see that thing. 112. 6 paragraph. On request. 113. 113. Court notice. 14. 14. Office of Mohammed done. Yes. What is this matter?
I said here, the petitioner was convicted under section 324 IPC, RI for 3 years and fine of 1,000 rupees.
Get ready for 6. For 6, get ready. 6. Welcome for representation 6 adjournment. Leads to account. 15. 15. Here also, Mr. Dhar. Mr. Dhar. 6. On request 6. 16.
You said some of that conviction. A person is convicted on 409, 3 years, and fine 3,000 fine. Let it be some other terrorist.
6.
Next, I have I could not contact. I have written a letter. 6. Next 1 week after.
1 week.
Great.
Next week. Okay.
117.
Court notice. Now there are two matters. The, yes. You are the 100?
99.
99, yes. What is this matter is about?
My lord, the petitioner convicted under section 47A of Bihar and Odisha Excise Act.
Okay.
And sentence 2 year simple imprisonment, 500 fine.
How much you have undergone? Not found.
LCR not there, madam. LCR not there.
Okay. Give it. Sixth, huh?
My lord, take Xerox.
Huh?
File is not with him. For that, we have
File is
document directly registered to supply copy.
Letter comes to the petition submits that he has lost the file and he needs to reconstruct the file. Let the copy of the paper book may be supplied to letter comes to the petitioner. Release the matter on 6th.
Paper
Get a
not,
copy.
paper would not prepare, my lord, the revision cases, my lord. The brief of the that.
Yes. Soft copy also, whatever
Yes.
copy give you.
is sub-probable.
Yes.
Your lordship,
Allowed more time.
your lordship, the conviction,
6th you come then.
Yeah.
At least you come and sit in the court. See how the other lawyers are.
your lordship, the conviction is under section 138 of Negotiable Instrument Act. And the petitioner had was sentenced to undergo rigorous imprisonment of 1 year and to pay a compensation of 63,000 rupees. And the appeal was dismissed by the learned trial court below. And the same was confirmed by the appeal court, by the appellate court, and for which the petitioner is here in the High Court.
6th you tell him to come. Okay. I will convert rigorous to simple. Okay. 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 Let us see in 6th some matters will be.
Thank you.
Thank you.